you. Good morning, all. This application hearing is in the matter of CFI 040-2025 and is being held by way of video conference before His Excellency Justice Robert French for the sitting of the hearing taking place in Dubai. Any orders or directions made during the course or after this hearing will be issued by the registry in Dubai on the judge's instructions. The claimants are represented by Reed Smith. Lead counsel is Mr. David Peters, KC, assisted by Mr. George McPherson. The second defendant is represented by Onima. Lead counsel is Mr. Andrew Trotter. Thank you.
Thank you. Before we start, Mr. Peters, you gave me a very ambitious reading list, I think. Mr. Trotter was more merciful. I did have some IT problems, but I have viewed the two expert reports and a number of relevant witness statements, as well as having read the skeleton outlines. So I have a reasonable understanding of what the issues are, and of course I've had some background, having been both on the Court of Appeal that dealt with this matter and in relation to the extension application. Now, Mr. Peters, have you had a discussion with Mr. Trotter about how you're going to proceed with this application? We've got a number of witness statements. And
yes, we've had a discussion about how best to structure our respective oral submissions and how to divide up the time, which is obviously subject to the court. Our current position is as follows. We've agreed that we will divide the 2 days equally between us. The plan is that Mr. McPherson and I will make opening submissions on all the issues arising on all the applications. And just so you're aware, Mr. McPherson will be dealing with discrete points arising in relation to Mrs. Gupta's discharge application, in particular, the alleged breaches of the duty of full and frank disclosure. Mr. Trotter will then respond on all issues, and I will reply. And then finally, Mr. Trotter will have a right of reply in relation to the discharge application because it's his application, and so it's fair to say he's entitled to the last word on that. We considered dividing things up in a more granular way, but actually given the overlap between the applications and the issues, that struck us as probably being more trouble than it was worth.
Yes, I had thought about whether the continuance of the Chabra finding was a kind of preliminary issue, but on reflection, I don't think it can be disentangled.
Yes, I think, and even if at first blush it appears that it might be capable of, I suspect that when one pulls at that thread, it risks becoming more trouble than it's worth.
Well, preliminary issues are notoriously hazardous. So, in terms of the record, I have the case bundle and various witness statements on that, and you'll simply be arguing, as I take it, about the effect of those witness statements and the responses to each of them, which are substantially argumentative. So much of it appears in any event, I think, in your skeleton arguments.
Yes.
All right.
My intention is to take you through the relevant documents in the hearing bundle. I hope you have one hearing bundle and one joint authorities bundle, to which I'll be referring.
Yes, I gave priority to the hearing bundle. The authorities bundle is there somewhere, so we'll no doubt get it out.
Well, I think, perhaps mercifully, that there's unlikely to be extensive legal argument on the principles. I think at least most of the domestic law principles are there are differences of nuance, but not fundamental differences.
Well, I think that's right. It's pretty fact heavy and argumentative. Mr. Trotter, do you have anything to add?
No, Your Excellency, that seems like a sensible approach from our side.
All right. Okay, Mr. Peters.
Oh, well, in that case, I will dive straight in. First of all, with how I propose to structure my submissions. So I will deal with the matters in the following order. First, I want to make some overarching introductory points. Second, I want to deal with the question of whether the requirements for a Chabra order are met in relation to Mrs. Gupta and her assets. And as you are doubtless aware, that gives rise to two sub-issues. First, whether and to what extent that question is open for debate at all. And second, if it is open for debate, whether on the evidence currently before the court, it can be satisfied that there is a sufficiently arguable case that the requirements of the Chabra jurisdiction are satisfied in relation to Mrs. Gupta and her assets. My third headline is whether this court ought to grant the variations which Trafigura seeks to the Chabra order which the Court of Appeal granted last year, and to which I will refer as the DIFC Chabra order. Now, again, that gives rise to sub-issues. The first, and we say principal one, is whether stronger measures are needed to ensure compliance with the court's orders, and that in turn raises questions in relation to Mrs. Gupta's breaches of those orders. And then where the overall balance of convenience lies, which raises issues as to the relative prejudice to the parties of varying or not varying the existing order and general discretionary factors. I will then hand over to Mr. Macpherson to deal with the discharge application, and then finally things will come back to me to deal with the discrete application for disclosure in relation to Mrs. Gupta's litigation funding arrangements. So, Your Excellency, introductory points. I do want to start by making some overarching points concerning what we say this hearing is about and what it is not about. As I said, the starting point is that Trafigura already has the benefit of the DIFC Chabra order, which is an order designed to prevent the illegitimate disposal of the assets which it identifies. The suggestion, repeatedly made on Mrs. Gupta's side, that that order is something which merely gives Trafigura a window to apply for further relief, if so advised, is wholly inconsistent with the clear and express wording of that order, for reasons that I will explain in detail in due course. On the variation application, it is Trafigura's position that, because of Mrs. Gupta's breaches of this court's orders, including what we say are very serious breaches of the DIFC Chabra order, the level of protection provided by that order has proven to be insufficient and needs to be beefed up. Now, in the ordinary course, an application framed in that way would lead to a relatively simple exercise. One would analyse whether and to what extent Mrs. Gupta was guilty of the breaches alleged, and then assess whether the further relief sought by Trafigura was, in all the circumstances, a reasonable and appropriate response to those breaches. However, as I suspect the court is already well aware, this hearing has grown into a significantly more complicated beast, essentially as a result of Mrs. Gupta's attempt to use it as a vehicle for arguing the merits of the grant of any Chabra relief against her from scratch. Now, we say that is odd, not least because there is one application which is not before the court and which might be thought to be notable in its absence. There is no application by Mrs. Gupta to set aside the DIFC Chabra order itself. And that is not, we say, an accidental omission. Such an application would be bound to fail because, having fought unsuccessfully against the grant of that order at the inter partes stage, any such application could only properly be advanced if there had been some relevant material change of circumstance, and there hasn't been. And we do say that it would be inappropriate for the court to permit this hearing to become the vehicle for a collateral attack on the DIFC Chabra order itself, but on a proper analysis, that is precisely what many of the points taken by Mrs. Gupta seek to do. Now, given how matters have developed, there is unlikely to be no option but to dive into the full complexity of the evidence and arguments now before you. But we do say it's important not to lose sight of the essential simplicity of what we are actually asking for on the variation application. And my more detailed submission should be considered with that, as it were, at the back of your mind. So
you have at present the benefit of a notification order in effect, don't you?
Well, I'm going to address you on that in some detail. We have the benefit.
The question is not whether that's inherently, well, is it inherently ineffective, or is it just a matter of difficulty with enforcement. There's been a debate about whether there was adequate or any notification in relation to a disposal.
Well, that is foreshadowing what I'm about to argue. It is an injunction that requires notification. It is, in fact, when you look at it, an order that provides protection which is functionally identical to, and in some respects, actually even more exacting than a full-on freezing order. And I will make that good by reference to the terms of the order in due course.
But what I'm asking is, what in principle, what is the what's the rationale for moving from a notification order to a not without consent order?
Well, the basic point, which again I'll have to make good on the material, is that we are reversing where the burden for coming to the court lies. Because the notification provisions mean that if we are notified of a transaction that we don't like, we have an opportunity to come to court to stop it. But of course, that only works if we are given notification in proper time. Well, we have to be given notification at all. The notification has to be given in proper time and given in proper form. Otherwise, our right to then come to court and object to the disposal is frustrated.
And the criterion upon which you get a CHABRA order is reason to suppose.
Yes.
No, or good reason to suppose.
Yes.
And so there is a balancing of legitimate interests, your protective interest, her interest in the assertion that this is her property and no one else's. And we don't have a final answer to that. We have the expert reports are all about the sort of arguable inferences that might be drawn from looking at various documents. So, I mean, one question might be, why is it necessary to appropriately meet that balance to move to a not without consent, a more draconian provision, rather than perhaps giving some more teeth to the notification requirement, whether it's in terms of the period or in terms of the content, or both?
Well, I can see that. Can I ask Your Excellency, I'm going to sort of take this in stages, and I'm going to develop that point. That is one of the subheadings in my submissions. And what I will say in due course is, given where we've got to, the only fair response is now to move to what one might call a full-blown freezing order. And but if I may, I want to get to the detail of that when I get to it, because
I think I know the landscape which you're crossing, because I've read your skeleton and I've read the responses.
Yes.
And it would be interesting up front to know the ultimate mountain to which you want to take us, why you want to take us up that particular mountain.
Yeah. No, I understand that. The point is, the notification requirements have been repeatedly flouted, we say, in a way that suggests that, and the problem is, if you just beef up the notification requirements, you are just doing a modified version of that which has failed to work properly. And we do say it has failed to work properly. If you move to an unqualified freezing injunction, then the burden of persuading the court to intervene reverses. And it is then for Mrs. Gupta to come to court and say, this is a legitimate transaction, this is why, these are the particulars. And what it obviates is the possibility of her doing what we say she's done a lot of, which is putting in documents that look like compliant notifications and are, in many instances, clearly an opportunity to give what she thinks is the bare minimum required by the order, and is in fact a long way short of that required by the order.
But you can address that problem by specifying what the content of a notification should be, perhaps even attaching a form to the order.
The problem with that is that, first of all, if you've got someone who is playing these sorts of games with notification, that just changes the field on which those games are played. If you've got someone who is filing notices that are false, and we do say that in certain important respects, on her own current evidence, she has filed notices which were just false, then that rather undermines the utility of any notification requirement, because if you've got someone who is simply saying things in a notification that aren't true, there is no regime for specifying a notice that can deal with that. But the other point is that, yes, you can have detailed notification requirements. Actually, the existing notification requirements are already significantly more detailed than the standard form notification requirements you'd have in a freezing order or a CHABRA order, precisely because this problem was foreseen. But the difficulty is, given the infinitely various nature of possible dealings with possible assets, it is actually impossible to define in a notification provision the material. We also say that, as you said, there are two sides to this balance. We say there is a real legitimate interest in changing matters in the way that I have indicated. But we also say that if you look at it, the prejudice to Mrs. Gupta of doing that ought to be relatively modest. And that is a submission that I want to develop by reference to the documents. And such prejudice as there is more than comfortably overridden by the prejudice to us in light of what has happened.
Yes, go on, please.
So I was going to start with my first topic, which is the first bit of entitlement to CHABRA relief, which is the matter up for debate at all? Now, on this, our case is very simple. We applied for the DIFC CHABRA order, and it was granted by the Court of Appeal until further order, on the basis that Mrs. Gupta's relevant assets were amenable to the CHABRA jurisdiction. And whilst Mrs. Gupta did vigorously object to the continuation of that order at the inter partes stage before the Court of Appeal, she did not do so on the basis that her relevant assets were not amenable to the CHABRA jurisdiction. The time at which she could therefore properly take that point has come and gone, and it is inappropriate to allow her to take the point now, particularly, as I say, in circumstances where there is no application to set aside the existing CHABRA order, and it would be inappropriate to allow a collateral attack on that order. Now, unfortunately, to make good that relatively simple case and to correct what we say are the misapprehensions and mischaracterizations on which Mrs. Gupta's arguments on this point are based, it is necessary to do something of a trawl through the history of the case.
Well, that takes me back, or takes you back to the English proceedings, doesn't it? And what happened
Yes,
before?
I was going to start with
Justices Pelling and Cockerill.
Yes, exactly. And I was going to do a
trawl.
Well, sorry.
I think I've seen the trawl. Can you encapsulate it in a fish?
Yes, of course. In summary, when we applied in England, we identified three assets of Mrs. Gupta that we said she was arguably holding for Mr. Gupta, and that's Villa KO1, an interest in a Silver Star, which you may have seen reference to, and monies held by Mr. Gupta's solicitors on their client account, on the basis that it had been explained that Mrs. Gupta was paying Mr. Gupta's legal fees at that stage. Now, at the without notice stage, His Honour Judge Pelling was persuaded to make a CHABRA order freezing the first of those two assets, essentially on the basis that he was persuaded that Trafigura had a sufficiently arguable case that Mrs. Gupta's own resources were insufficient to explain how she'd come to own assets of such substantial value. He was not prepared to make the same finding about funds held on account by Mr. Gupta's solicitors, essentially because he thought those sums were likely to be much lower in value and therefore more readily explicable on the basis of being proceeds of Mrs. Gupta's own wealth. It is also right to say that the judge was not prepared to grant a maximum sum order over all of Mrs. Gupta's assets, essentially because he didn't have any evidence as to what they were. And I can take you to the passage of his judgment if that would be helpful, but it effectively said, well, I'm prepared to freeze orders you've been able to identify, but I'm not prepared to freeze orders freeze assets that you haven't.
Yep, that's right.
And so the judge, but importantly, the judge was prepared to accept the proposition that Mrs. Gupta was arguably holding assets of substantial value as a nominee for Mr. Gupta, and he froze the valuable assets that we could identify. He also made an order for asset disclosure precisely in order to enable Trafigura to identify whether there were other similar sorts of assets that should also be frozen. Now, the order he made froze Villa KO3 and the interest in Silver Star. It also froze any interest in any company which directly or indirectly held the interest in Silver Star. Now, that was a fairly open-ended provision that was included because we didn't know when we obtained the order how Mrs. Gupta held her interest in Silver Star. On the information we now have, we know that she holds it through this company Vision, and therefore the effect of His Honour Judge Pelling's order was in fact to freeze her shares in Vision. And a further corollary of that is that anything which Mrs. Gupta procured Vision to do with its assets, which resulted in a reduction in the value of her shares, would also be prohibited by His Honour Judge Pelling's order, because it would result in a diminishment in the value of the assets that were frozen. Now, in her asset disclosure, Mrs. Gupta explained that she owned Villa KO3 and Vision, and that Vision owned various substantial assets of potentially significant value, such that the book value of Vision was said by her to be about $37 million. Now, given the logic of His Honour Judge Pelling's ruling, there can be little doubt that had Trafigura had evidence as to the existence of those other assets at the ex parte stage, the judge would have frozen those assets as well. Now, that presented at the time Mrs. Gupta with a dilemma. She could mount a root and branch attack on Trafigura's entitlement to Chabra relief, or she could do a deal. And she chose to do the latter. And the deal she was able to agree is set out in Mrs. Justice Cockrell's order. And I think perhaps it is worth going to that, because these are the provisions that are then replicated in the DIFC order, and about which there has been, the effect of which there has been some debate. So can I ask Your Excellency to go to page 8038 of the hearing bundle?
Can you give me the alphabetical and numerical designation? There's a alphabetical index, I think.
Ah, that is
in the case bundle.
I've been doing things by PDF page number.
Have you? All right. What's your page number?
8036.
See how this goes. It's a bit like
sorry, 8038.
Eight. All right. See how we go.
So hopefully you'll have the order of 6th of June 2023.
I'm having difficulty accessing it. Don't want to waste time with this.
What I might
there is an alternative index which has each class of document has an alphabetical designation A through to M, and then then there's a numerical designation to, wait a minute, I might be able to find it this way.
I'm sorry, Alex. I think the problem is that the version of the bundle that I have downloaded from the DIFC court system doesn't have that designation in it, or at least the version that has come onto my computer doesn't have it.
Well, mine does. Anyway, perhaps you can just have you reproduced the terms that the text that you're wanting to refer to in your skeleton?
Not all of it, but I can read it out because it's
just
fairly...
give me the as were the good stuff. I think I've already read about this.
Yes. So the starting point is you have an injunction which is said to be subject to the Schedule C, which prohibits the disposal of, diminishing the value, dealing with Villa KO1 and the shareholdings in Vision. And then at Schedule C, you have the bit that is perhaps more controversial. Now that identifies what are called, as we will see somewhat euphemistically, excluded assets, which are Villa K3 and a list of 15 properties owned by Vision.
Yeah.
And what it says about that is that the respondent may deal with those assets, but subject to a series of undertakings. So the first undertaking is that any such dealings will be made at reasonable market value and not for an undervalue.
Yep.
The second is that the proceeds of any such dealings may only be used for certain designated purposes. The first is ordinary legal expenses and living costs. The second is further loans to Mr. Gupta to fund his legal expenses. And the third is the necessary and reasonable costs of operating and or maintaining the assets. We can skip over.
I'm familiar with all those.
Yeah.
So then, this reflects an agreement between the parties, obviously involving an undertaking, which has injunctive effect approved by the court.
Yes.
But does not of itself involve a finding by the court, does it, of good reason to suppose in respect of those particular assets?
Absolutely not, and I wasn't proposing to argue to the contrary.
So far we've got a Chabra order based on that finding in relation to KO1 and the shares
in Vision.
Yeah.
Yes, that is quite right. The point I wanted to make about the schedule is that, remember, if you get a freezing order in relation to an asset, the standard form freezing order allows you to deal with that asset, despite it being frozen, to pay your ordinary legal expenses, your living costs, and costs incurred in the ordinary course of business. And normally for ordinary course of business expenses, you just have to provide a fairly bland notification saying that you are proposing to deal with assets in the ordinary course of business. My point is that actually these undertakings, although they are framed in a way that is perhaps sounds less like a freezing order, in practical terms, Mrs. Gupta wasn't allowed to deal with the assets at all unless she provided a notification that is more detailed than the standard form notification in a standard form freezing order. And then when she dealt with the assets, was only able to use the proceeds for certain specific nominated purposes. So we say, and it's in a point that comes back later, that the level of protection in that order is functionally equivalent to a standard form freezing order over what are called the excluded assets, and is in some respects even more exacting than such an order. Now, that is why we dispute a point that is taken about this order and the Court of Appeal's order in this jurisdiction, which is to say, oh, it's just to give you a chance to apply back to the court. That's actually completely wrong. The undertakings imposed significant limitations on Mrs. Gupta's freedom to deal with the relevant assets. So that's England. The next step, and perhaps more important step, is the application for Chabra relief in this jurisdiction. And here, I think it is worth, I need to go through how it was put. So the evidence here starts near the beginning of the hearing bundle. And perhaps we can do this by tabs. So the first bit is the supporting affidavit in support of the application, which is tab 2, page 7 of the bundle. So there you have Mr. Lakin's supporting affidavit. If we could go down to page 17.
Just a minute. This is Mr. Lakin,
Yes,
and which of his statements is it?
it's his very first affidavit. This is the affidavit filed in support of the original without notice application for the order.
Okay. Yes, here we are.
And if you go to page 17 of the bundle, internal page 11 of his statement.
Yeah.
And at paragraphs 46 to 51, he simply provides an accurate summary of what had happened in England. But then later in this statement, if we go to page 32, so the bundle page 32, internal page 26 of the statement.
Paragraph
127. Well, first of all, the heading, you'll see test for obtaining a freezing order against Mrs. Gupta. And then
yes.
At 127 to 130 over the page, he deals with jurisdiction. And then at paragraphs over the page at 131, paragraph 131, he deals with Trafigura's case as to its substantive entitlement to Chabra relief. And then you'll see at paragraph 132, he refers to the fact discussed earlier in his statement and common ground in any event that Mrs. Gupta appeared to be holding assets of considerable value. He then makes the point that to the best of Trafigura's knowledge, Mrs. Gupta did not have sufficient independent resources and all sources of income to explain how she'd come to hold assets of such value. And you will see at 1322, he did that by way of cross-referring to Mr. O'Keefe's evidence from England. Now, that was a perfectly sensible thing to do because although our knowledge as to the assets held by Mrs. Gupta had increased as a result of the disclosure given in England, our knowledge of her historical sources of income and wealth had not changed because there hadn't been any debate about them in England. And if we then go over to paragraph 34 page 34, paragraph 134.
Yes.
You'll see that Mr. Lakin identifies the other issues bearing on the substantive entitlement to Chabra relief, including risk of dissipation. The point being that if Mrs. Gupta is holding assets as a nominee for Mr. Gupta, there is clearly a risk that he would procure the illegitimate dissipation of those assets, and that risk, as it were, infects Mrs. Gupta as the nominee holding them. And the point I make is that, in essence, Trafigura advanced before this court precisely the same substantive case as had been advanced before His Honour Judge Pelling, and on the basis of which he had been prepared to grant the English Chabra order. The only difference was that Trafigura sought an order from this court in respect of assets which had not been the subject of its original without notice application in England, because those were additional assets which Mrs. Gupta identified in her asset disclosure, and in relation to which she'd provided further particulars when agreeing the regime of undertakings in England, which we discussed a moment ago. So, next step, I want to take you to the way it is put in Trafigura's skeleton for the original without notice application. And that is tab 5 of the bundle before you. And I want to start at page 57.
Yes.
So there, at paragraph 39, you have summarised the course of the English Chabra application. If we then go down to page 70, sorry, that's a false reference. If we can go to paragraph 71 on page 64. Apologies, Your Excellency.
Yes.
You have the position on jurisdiction, and then if we go down to page 79, which is section E2 of the skeleton argument, Trafigura sets out its case for the Chabra relief sought against Mrs. Gupta. And you can see that there the point is made that Trafigura satisfies the substantive requirements for the grant of a Chabra order. And then finally, if we can complete
when you say satisfies, you mean advances the argument that a Chabra order is appropriate on.
Yes, exactly. But my point is, and I'll come back to this in a moment, we weren't saying you should just do what has been done in England. We were saying we are entitled to a Chabra order in the form that we were seeking. And that is the way the case was being put to the DIFC court. And if we could go to the next tab of the bundle, which is the transcript of the hearing. This is the without notice hearing before Deputy Chief Justice Al-Madani, and go to page 113.
Yes.
And then you'll see if it's transcript page 90, which is in the bottom left-hand corner, starting at line 18. Trafigura's then counsel says, as against Mrs. Gupta, as I mentioned, she's not a defendant, but there is reason to believe she holds assets on behalf of Mr. Gupta. Just to show you that the and then he deals with the law. And then if we go over to the following page, transcript page 91, line 14. So we rely on the same reasons given in England, namely that Villa KO1 and Villa KO3 are held by Mrs. Gupta, but she appears to lack the means to have acquired them. Now, in England, at that stage, His Honour Judge Pelling didn't consider Villa KO3 because we didn't know about it. But he did make that conclusion in relation to KO1 and Vision. At that stage, I think the focus was on a different entity within the group, but the point remains the same. To the extent that there are valuable assets, we say, she does not appear to have the means to acquire them herself, so there is reason to suppose that she is holding them for her husband.
Okay, so the point of all of this is that you made submissions that the Chabra criteria would be satisfied in support of a so-called Chabra order.
Yes, and the critical points, yes, exactly. We came before the DIFC saying that we satisfied the substantive requirements and jurisdictional requirements for the grant of a Chabra order, of the grant of the Chabra order that we ended up obtaining. We were not applying for recognition or enforcement of the English order. And as I say, it was not an application which sought a Chabra order from this court on the basis that it should, without more, copy the English court's order. The fact that the English court had already made an equivalent order was obviously a relevant part of the background and will perhaps have been relevant to the exercise of the court's discretion. However, at the risk of stating the very obvious, the fact that a foreign court has made a particular order does not itself confer jurisdiction on this court to grant the same order or render it appropriate in principle or as a matter of discretion for it to do so. If you want a Chabra order from this court, you have to explain why you're entitled to it. And that's what we did.
Well, happily, nobody's raised transnational issue estoppel, so we don't have to go there. Now, of course, you lost before at first instance. You won in the Court of Appeal on an ex parte basis initially, and then inter partes on the question of jurisdiction, really, and power, wasn't it?
Yeah.
Yeah.
So what happens is that we failed at first instance, but in the course of his judgment, the Deputy Chief Justice made clear that he was with us on the merits. if I can put it that way. He dismissed the application on jurisdictional grounds, but he did say in terms that but for that, the requirements for the order he thought were satisfied.
Well, with an ex parte order, of course, the most you can say of such a finding is that it is provisional.
Of course, yes, absolutely, and that's why it's only a step in the story.
Yeah.
Now, I suspect I don't need to take you through the detail of what the Deputy Chief Justice did at first order. I was going to move on to the appeal. Now, again, starting with our submissions, our skeleton, and can I suggest, if it's convenient to the court, I will give references, but we don't necessarily need to turn all of them up, so you have them and they're on the transcript.
That's fine.
So starting with our skeleton argument in support of our application for permission to appeal, at paragraph 4, which is page 145, we recited correctly that the judge below had found in favour on the substance of the applications.
Why do we need to go to the PTA? All that is
actually, you're quite right. Perhaps the easier thing to do would simply be to go to the ex parte hearing before the Court of Appeal, and then the inter partes.
And that was just determining whether there was an arguable case at the ex parte stage for the granting of the order that was made. And that's why the appeal was heard. The appeal was heard ex parte, but for the final decision, that it had to be inter partes, obviously.
That's right. So you have an ex parte hearing, and I think there were actually two grounds of appeal. The first was that we were right on jurisdiction, and the second was that we were arguably right on jurisdiction.
Well, I think you got up at the first instance on the basis that you were arguably right on jurisdiction. That's exactly all the court could say in the absence of the other party.
Exactly. And so what the Court of Appeal did is we said, well, we're going to allow the appeal ex parte because you're arguably right, and the matter is then going to come back before the court inter partes, and you can have the argument.
Yeah.
So the Court of Appeal did consider the matter inter partes. The hearing was on the 2nd of September last year, and judgment was handed down on the 22nd. So the judgment, most of it relates to the issues of jurisdiction and does not therefore concern us. However, it did record at paragraph 59, page 420, that the Deputy Chief Justice's finding that the substantive conditions for relief were met. And so the Court of Appeal was rightly proceeding on the basis that, as it were, the substance had been determined, and that at least at that stage, now we're talking about the inter partes stage before the Court of Appeal, that determination was not subject to dispute. So the question that arises out of that is, where does one end up at the end of the Court of Appeal judgment?
Well, you end up with you have an ex parte finding that it's arguable. That it's arguable that there is good reason to suppose. And the debate before the Court of Appeal was really all about jurisdiction and power. Yeah. So debate was never joined on an inter partes basis on the question of Chabra jurisdiction and power. I'm sorry, I should say power, really.
Yes. Well, what the point I'm making, it's quite right that the Court of Appeal, it sort of took that as read. It was dealing with a jurisdictional issue. But the question is, what then happens next? Well, the Court of Appeal made an order sending the matter sort of back to the Court of First Instance to deal with a few essentially administrative points. The first was necessary variations to the order to take account of the appeal. The second was necessary fresh undertakings by Trafigura, and those were simply things that had arisen out of the time that had passed since the original order was made. And costs. Now, the point is, subject to those essentially administrative points, the original Chabra order had been continued following an inter partes hearing. And that's an order that, as I say, can only be made on the basis that Mrs. Gupta's assets are subject to the Chabra jurisdiction. Now, the question then is, well, why is there? I accept the Court of Appeal doesn't separately grapple with the substantive merits, but the obvious question is, why not? And the answer is
that wasn't there was no ground of appeal in relation to that. The ground of appeal related to jurisdiction and power, I guess, and that was the focus of the parties, understandably, and the focus of the court.
well,
So the question then is, what's the status of the finding that there's a reasonably arguable case that there is reason to suppose,
well,
which is as high as it got with
yes,
the first instance judge.
but that's as high as it would ever need to be.
No,
even
no,
on an inter-parties
there
basis.
are two levels. It's reasonably arguable that there's good reason to suppose. So there's never a final determination on that issue, whether there's good reason to suppose. And
So, but what has happened is that the Court of Appeal was dealing with jurisdiction because it was asked to.
Yeah.
And the reason that there has never been any further argument in the context of the application for the original order about our client's entitlement substantively to that order is that Mrs. Gupta has never challenged that point. So it's not so much a case, I think it's perhaps important to separate two different things in one's mind. It doesn't need, for my purposes, to be a case where something has been decided in a way that gives rise to an issue estoppel. The fact is, if we get an ex parte order, it comes back before the court inter partes, at which point Mrs. Gupta has her opportunity to challenge the continuation of the injunction until further order. Fact is, the injunction was continued until further order. Well, sorry, first of all, it's an order that was granted and could only have been granted on the basis that her assets were amenable to the chapter jurisdiction. It was granted, it has been granted until further order. So we are now past a completed inter partes stage. And the reason why there is no more detailed debate about the status of her assets is because she didn't raise the point. You see, this is the issue with the way these types of applications work. There is an element, we say, of, frankly, put up or shut up in relation to the inter partes stage of ex parte orders. If you want to say that the person who's got the injunction shouldn't have it until further order, then you've got to stand up and say that and say why. And if you want to apply to discharge the order after the inter partes return date, then ordinarily you'd need to come to court with some material change of circumstance. So the point is this, that order has been continued. The absence of any further, as it were, granular determination of the status of Mrs. Gupta's assets is the direct result of her not raising that point. If she wanted to raise it, she should have raised it when the question of whether the order would continue inter partes was live. And if she says that it is still open to her to apply to discharge that order, she doesn't say that, but were she to say that, then the correct vehicle for that argument would be an application to discharge that order. And no such application has been made. But what you can't do, where an order has been continued inter partes, all we are saying is we want a variation to that order. And the essence of Mrs. Gupta's position is, no. Because I didn't take the point earlier, brackets, when I could and should have done, I now want, in the context of your variation, to go right back to the beginning and re-argue your substantive entitlement to the order that you've already got. And the order, frankly, that I don't challenge. Now, a part of the history that is quite important here is that until very recently, everything that I've just said was understood by us to be common ground. And indeed, it was, we say, understood by Mrs. Gupta to be common ground. Because in her second witness statement, which was filed in response to the variation application on the 5th of January 2026. It's at page 760 of the bundle, but Your Excellency, I can read out the paragraph that we rely on.
Okay.
She said, although I am not a defendant in the English proceedings, this court and the English High Court have established that there is good reason to suppose that I hold assets that belong beneficially to Prateek, and restricted me in the use of those assets. Now, just to be clear, this is a time when she does have the benefit of legal representation, so this is not something inadvisedly put forward by someone acting as a litigant in person. And she's right. And she's right in both respects. She's right that this court had made orders on the basis that her assets were amenable to the Chabra jurisdiction. She's also right that those orders restricted her in the use of those assets. So until this point, this is standard fare in the context of this sort of application. You get a freezing order or a Chabra order, the respondent challenges some points and they win or lose on those points, and they don't challenge on other points. And the order continues, and the points that they lose on, they can't take again. And the points that they challenge, they can't take at all, because their moment to challenge them has come and gone. That is, of course, in the absence of a material change of circumstance. Now, that was the position until Thursday, the 19th of February this year, which is 2 clear days before the hearing in front of Chief Justice Martin on the 23rd. That is when Mrs. Gupta served her skeleton for the initial hearing of the variation application. And that document raised for the first time the suggestion that the amenability of her assets to the Chabra jurisdiction had not been considered and was therefore up for grabs. And indeed went as far as to say that the variation application involved Trafigura seeking Chabra relief for the first time. Now, that was encapsulated in paragraph 20 of the skeleton for the without notice hearing, but it's also been transposed, I believe, into Mr. Trotter's hearing for Mr. Trotter's skeleton for this hearing, which I'm just going to find quickly. If you give me a moment.
Well, I don't need that. We know that we need to go into the granular history of what people. You've made your major point, I think, and then we got into the forensic experts. I mean, this is why we saw the accountant's report on.
Yes, this is why we saw various things
going to the question whether there was reasonable ground to suppose.
Yeah.
Okay.
But the reason I wanted to take you to
and that led to the further adjournment before Chief Justice Martin, because she wanted to bring back responsive evidence, so forth. So there was a full-on fight about Chabra.
But the way the case was being put at that stage, and is still being put, is that and this is a quote from my learned friend's skeleton both then and now. C's have not sought to establish any entitlement to Chabra relief in respect of the Schedule C assets. And no court has adjudicated on whether there is reason to believe that Villa K3 or the Vision properties are beneficially owned by Mr. Gupta. Now, that is just completely wrong. And indeed, it's obviously wrong on the basis of the documents I've shown you. Trafigura actually absolutely did put its application for the original order on the basis that it was entitled to Chabra relief. And indeed, its application would necessarily have been dismissed as a matter of course if it hadn't done so. And as to the history of the determinations and then the point being unchallenged, I've taken you through there. I've taken you through that. So what does Mrs. Gupta say about this? Well, firstly, she says there's been no determination. And so it's all up for grabs. And that's wrong for the reasons that I've just been developing. Second, she says that at the hearing on the 23rd of February, Trafigura made a binding concession that the amenability of her assets to the Chabra jurisdiction had not been resolved, such that it is now abusive for Trafigura to argue to the contrary. Now, we do say that that separate submission is clearly wrong for a number of reasons. In essence, the hearing on the 23rd of February was abortive. Nothing of substance was decided at that hearing, and further directions were given. It's right that Chief Justice Martin was concerned about the issue of what, if any, prior determinations there had been about the amenability of Mrs. Gupta's assets to the Chabra jurisdiction. However, that was the result of the point, as I say, being raised at the last minute by Mrs. Gupta and being put in a way that was directly contrary to what she said before. In other words, there was...
Mr. McPherson said the question has not been separately determined. No, because it hasn't needed to be.
Well, I was going to come to that, because that passage from the transcript, we say, has been quoted quite badly out of context and is actually an object lesson in why the court does not normally find that there are binding concessions giving rise to an abusive process out of off-the-cuff exchanges between the court and counsel in the heat of a hearing that is developing quickly. Your Excellency, it may be that it gives rise to a technical issue, but I do actually think it's worth having the transcript up in front of us on this point. The exchange is at bundle page 847. Again, if it would help, I can read it out.
Yeah, do that. It'll save time.
Yeah. So you need to start with the context of the Chief Justice's question. He says, I don't know why she undertook what she did. Now, that's Mrs. Gupta's undertaking in the English proceedings. It may simply be that they wanted to avoid the fight about whether there were Chabra assets or not. So he's talking about the English proceeding, but the point is no determination. I haven't seen anywhere any determination by any court that the assets in Schedule D are assets in respect of which there is reasonable ground to believe they would be amenable to execution. Has that ever been determined? And then, yes, Mr. McPherson says the question has not been separately determined, no, because it hasn't needed to be. Interestingly, that is in fact entirely consistent with what I've just been saying about the point not being determined because it wasn't raised by Mrs. Gupta as a point of dispute. But putting that on one side, Chief Justice Martin then says, when you say separately determined, has it been? What do you mean by that? Either it's been determined or it hasn't. It hasn't been determined, has it? And Mr. McPherson then says, it hasn't. No, it hasn't been determined because the Chabra determination obviously took place before His Honour Judge Pelling, and then further assets that were captured, as I've explained, were subject to the undertakings. Now, if one looks at that, and it may be, if you're in the course of preparing judgment, it's worth looking back at it. Mr. McPherson was talking about the position in the English proceedings, and he was completely right in his description of the position in the English proceedings. We say that there is nothing in that exchange which contains any concession about the position in this court, still less a concession which in all the circumstances could give rise to an abusive process. And I should point out that we are not aware of any authority in which it has been found that that sort of off-the-cuff exchange, made in the context of a hearing at which nothing of substance was decided, has been held to be capable of resulting in a binding concession and an abusive process. And we therefore say that Mrs. Gupta's abusive process arguments are wrong on the facts and indeed and unprecedented as a matter of analysis. We also say, so we do say that it's clear that the question of our entitlement, of whether our entitlement to Chabra relief has already been established, is one on which no concession has been made, and we're free to argue the point as we see fit. We also do say that that is the view, that was the view of the Chief Justice, and you get that from the ruling that he gave on the application to adjourn this hearing when it was previously listed for April. Again, Your Excellency, if Pat, I can just read it out. at paragraph 4, he recorded Mrs. Gupta's proposal that this very issue about has it been determined or does it need to be redetermined should be carved off as a preliminary issue. He rejected that. He says, the issue with respect to the need for the claimants to establish that there are assets amenable to the Chabra jurisdiction is a relatively short point, which can be determined by any judge of the court on the basis of fuller evidence and argument than was presented to me on the 23rd of February 2026. So he clearly and rightly thought that the debate on that point at the February hearing was inconclusive. And he was rightly alive to the fact that he hadn't been taken through the history of how the matter had been presented in England, how it had been presented ex parte in this jurisdiction, how it had then been argued inter partes in this jurisdiction. And as I say, when you look at that history, actually the correct analysis is clear. The order we have in hand is a Chabra order, and it could only have been granted on the basis of the assets to which it refers were amenable to the Chabra jurisdiction. We presented our application to this court for that order on the basis that that was the case. In other words, that the assets were amenable to the relevant jurisdiction, and the Deputy Chief Justice accepted that they were. Thereafter, the point did not arise because the debate before the Court of Appeal turned on a discrete issue of jurisdiction, and Mrs. Gupta did not, and to date still has not, objected to the DIFC Chabra order on the basis that her assets are not amenable to the relevant jurisdiction. And so we do say that her attempt to raise the point now is too late, and it's an impermissible collateral attack on the order that we have in hand. And we do go back, I therefore go back to the point I made briefly at the outset, which is this matter should be determined on the same basis as any other application to vary a subsisting and unchallenged interim injunction. Namely, that one considers whether the specific variations sought are justified by the specific events which have occurred since the order was granted, without considering afresh whether the substantive basis for the original injunction is itself made out. So that's what I was going to say about it's already been, either it's already been decided or perhaps more accurately, it's not up for grabs today.
You said everything's possible to say, Mr. Peters. And perhaps a little more. I've often been tempted to say the council. Thank you.
I was then going to turn to part 2, which is if you're against me on that, our entitlement to Chabra relief on the merits.
Yeah.
Now, of course, this point doesn't arise if you are with me on what I've just said, but on the assumption that you're against me,
we've got here, I mean, I don't want to sort of get lost in the weeds here. We've got here, among other things, a couple of dueling forensic accountants reports, which are not amenable to, are not of the kind that will support a finding one way or the other. That this was Mr. Gupta's money, Mr. Gupta's assets, but rather the question whether, looking at both of them and such other evidence as you rely upon, there was reasonable cause to suppose that, in other words, the criterion for the grant of a Chabra order had been, which doesn't rise above the level of arguability, I guess.
Well, Your Excellency, you've somewhat stolen my thunder. That was exactly what I was about to say. I was going to say, given the proliferation of evidence, you might be forgiven for thinking this was a trial and that you were being asked to rule substantively on the issue of how Mrs. Gupta came to acquire certain assets and whether she holds them for her husband. But of course, that's not the position. In order to obtain the relief we seek, well, in order to obtain the relief we've already got, Trafigura needs to make out a good arguable case that Mrs. Gupta is holding assets as a nominee for her husband, such that judgment against him would be enforceable or might be enforceable against those assets. And for those purposes, a good arguable case means one that is more than barely arguable, but not one which the court necessarily thinks has a more than 50% chance of success. So that's our burden, to show that we have an arguable case that she's holding assets for him. What that means is that the burden, if they wish to shoulder it on the, or she wishes to shoulder it on Mrs. Gupta, is the much higher one of showing that we don't even have an arguable case to that effect. Now, as a result, and as we will see when I address it in more detail in a moment, much of Mrs. Gupta's evidence as to the source of her assets misfires, in that it might be said to disclose triable issues as to how she acquired her assets and how she holds them, and therefore whether we are right or wrong in what we have alleged. But none of that is relevant for present purposes. The existence of a triable issue on a point is no answer to our case that we meet the relatively low threshold for a grant of Chabra relief. Now, with that introductory point out of the way, and turning to the substance of my submissions, I was going to deal with matters in two stages. First, I was going to address the factual position in relation to assets, and then I was going to address issues of UAE law which arise in relation to potential enforcement of those against those assets. But just to be clear, I was planning to do that very much with my focus on the establishing of an arguable case on our side, rather than trying to encourage you to the answer.
Is there an interaction between there is ordinarily in the grant of injunctive relief between the strength of the arguable case for which you contend and the balance of convenience, that is the adverse impact if an injunction is granted or continued?
I think the answer is somewhat, but it's not a sort of straight line relationship, if I could put it that way. It's not that in marginal cases, in a case where it is found, for example, that a claim just is perhaps very speculative, but just squeaks over the good arguable case threshold, and where it is also weak in other respects, or there are discretionary factors against it, you can see how in those circumstances, taking everything in the round, but it's not a case of the better your case, the more likely you are to get an injunction, and the worse your case, the less likely. Does that make sense, Your Excellency? In other words, it's something that might come into play if the application is marginal across the board.
And you, of course, make an undertaking.
An undertaking in damages, you mean?
Yes. Yes,
of course. Which, of course, Trafigura is good for. So on Mrs. Gupta's assets, I want to start at a relatively high level of generality, because given all the detail, it is quite easy to lose sight of the broad sweeps, and they're important.
What I've looked at particularly the overall summary of the position in the your accountant's report, and the skimming through it, the other one to the overall conclusions. And I see debates about inferences that can be drawn from dealings and documents and accounts and so forth. And of course, the question whether, and then of course there's Mrs. Gupta herself, that plays in Gupta 4, I think, with her explanation. So you can take it that I'm familiar with the landscape.
Yes, I mean, there are, I was perhaps going to proceed at an even higher level than that, but I will assume that, and doubtless Your Excellency will move me along if I am saying things that are overly familiar. So the starting point, at the risk of being very obvious, is that Mr. Gupta had very significant business activities and interests, which it turned out included the perpetration of what ought to have been, for him, a very lucrative fraud on Trafigura. So when the music stopped in late 2022, there was a net balance of 600 million due to Trafigura, representing sums which Trafigura had paid for what it was told were cargoes of LME grade nickel, but which were in fact cargoes of much less valuable or worthless material. Now, the obvious point is that until you get caught, selling worthless material at nickel prices ought to be an enormously profitable venture that generates an enormous amount of cash. such that one might expect Mr. Gupta and or his companies to be holding very large amounts of money or very substantial assets purchased with that money. However, as is not uncommon when one is dealing with a fraudster such as Mr. Gupta, that proved not to be the case. Before seeking a freezing order against him, Trafigura had been able to identify two assets of substantial value which appeared to be his, namely his home, Villa K1, and an interest in Silver Star, the Cayman entity which ultimately owned Silver Bank, a bank that you've seen has various associations with Mr. Gupta. Now, the asset disclosure which Mr. Gupta provided and his companies provided did not disclose assets at anything like the value one might have expected, given that they had over several years been receiving hundreds of millions of dollars in return for effectively nothing. So obviously one question that always arises is, where has the money gone? But at the same time, Mr. Gupta was also saying that the two substantial assets that I've just referred to, namely Villa K1 and Silver Star, were in fact owned by Mrs. Gupta. So, as you may recall from the materials I referred to a moment ago, Mr. Gupta was the person who you'd expect to have lots of assets, but he appeared not to. The two substantial assets which Trafigura had identified as potentially being his turned out to be in Mrs. Gupta's hands. And also, at that early stage, Mrs. Gupta was said to be funding Mr. Gupta's defence of Trafigura's claim. So you have a situation where one person, Mr. Gupta, should have the substantial assets, and another person, Mrs. Gupta, does. Now, as a result, Trafigura looks into Mrs. Gupta's financial history and finds nothing capable of explaining how she could be so apparently wealthy. And that is essentially the basis on which we obtained the Chabra orders both in England and here. Now, we've previously invited the court to proceed and continue to invite the court to proceed on the basis that in a situation I've just described, it's reasonable to infer, and there is therefore more than a merely arguable case, that what has happened is that Mr. Gupta has put assets which are really his into Mrs. Gupta's hands in an effort to keep them away from his creditors, and she's therefore acting as his nominee. So, for the purposes of this hearing, the relevant factual question is, on the evidence, is there a more than barely arguable case that that is what Mr. Gupta has done, and that Mrs. Gupta is therefore acting as his nominee? And that is what leads to the more detailed question, which has been the focus of much of the evidence that you've referred to, which is, what other potential routes are there by which Mrs. Gupta claims to have been able to acquire assets of substantial value? Now, the starting point in answering that question is the scale of the assets which she claims or claimed to have had. So I can take this from the asset disclosure she gave in the UK, which is in the bundle, but again, it perhaps might be easier if I just say what it says. So she disclosed villas KO1 and KO3, both of which are of very considerable value. They're both worth many millions of US dollars. She also disclosed that she owned Vision, and she was required in her asset disclosure to try and summarize the value of her interest in Vision. And she did that by identifying Vision's assets. And what she said, this is in May 2023, when she gives her English disclosure, she says that Vision had the interest in Silver Star, which was acquired for 31.6 million US dollars on an unspecified date, and also held shares in arm's length listed companies acquired for $22 million, again on an unspecified date, and various other items of somewhat lesser value. So the question arises, how did Mrs. Gupta, herself and or via her company Vision, acquire assets worth many tens of millions, and at times, as we will see in due course, potentially many hundreds of millions of dollars? Now, Mrs. Gupta has attempted to explain the sources of income which might justify this. And the details of that are to be found in her fourth witness statement. So again, I can turn it up, but perhaps it's just easier for me to take it. I have read it. So yes. You've read it, so I can summarize. So first of all, she addresses our point that neither her family wealth nor her salary from her employment were capable of explaining how she came to be so apparently wealthy. But she doesn't actually rebut Trafigura's point. She's not suggesting that her family or her employment actually did fund the acquisition of assets of that level of value. She then refers to this concept of having the benefit of Streeden gifts, but she's not identified the dates and amounts of those gifts or what was done with them. And so for the purpose of this hearing, she's not given evidence capable of supporting a sufficiently clear conclusion that any of the assets that we've referred to and which are subject to the Chabra order were acquired using the proceeds of those gifts. All her evidence does is identify what might ultimately prove to be a triable issue. This isn't a trial. She then describes her involvement in a metal trading business called GG Corporation, to which you'll have seen reference. And even on her own evidence, it's apparent that business did not generate monies which could have been used to acquire assets worth tens of millions of dollars. The only documentation she's produced is a brief profit and loss statement for a 4.5-month period up to August 2010, which shows that in that period, GG Corp earned profits of 824,000 odd Indian rupees, or about $18,000. Now, it follows that the only source of funds identified by Mrs. Gupta, which is even remotely capable of explaining the value of the assets held by her and Vision, are the alleged trading profits of Vision itself. However, her case on those profits and what has been done with them doesn't stack up in a whole host of different ways. So I am going to talk about what the Vision accounts that have been produced show, but I want, for the purposes of the discussion, to bear in mind that what we're talking about is Vision generating sufficient cash to acquire the assets which it ultimately came to hold. So on the accounts, again, Your Excellency, I could turn them up, but it may just be easier for me to make the points, and then we can go to the documents if the points aren't clear enough from my explanation.
They're covered in the expert report too, aren't they?
Some of it is covered in the expert report. Some of the numbers I'm going to address in perhaps a slightly different way, but can I suggest we see how we go? And it may be that there's no option but to go to the documents, but if so, we'll cross that bridge when we come to it. So starting with the accounts to September 2019, those showed that by far Vision's most valuable asset was an investment worth $164 million US, which reflected a 32% stake in a company called Hanji Global Limited. Now, on the balance sheet, that entry was cancelled out by a corresponding entry entitled Shareholder Current Account. Now, if you look at the accounts, what seems to have happened is that this interest in Hanji was contributed to Vision during the relevant accounting year at a value of $158 million. So the position is that Mrs. Gupta had somehow acquired an asset worth $158 million at the time and had contributed it to Vision. So obvious point, where on earth did she get that from? There is no evidence at all to explain how she could possibly have been in a position to acquire that asset in, say, some point in 2018 and then contributed it to Vision. It's also worth noting the accounts record the previous year's figures. She had also contributed 6.8 million by way of, it appears, shareholders' loan to Vision in the prior year. And again, there's no evidence capable of indicating how she could possibly have had access to that amount of money from her own resources. Sticking with the 2019 year, it is right to say, as she does in her witness statement, that the profit and loss shows an operating profit for the year of about 6.5 million US dollars. But given the importance of cash for present purposes, it is also worth looking at the cash flow position, which is that Vision is only said to have generated positive cash flow of $126,000 for the whole year, leaving it with total net positive cash flow of only $472,000. That's 2019. If we go forward to the following year, 2020, and this is the last year that I'm going to look at in any detail, you may be relieved to know, the balance sheet shows a huge jump in the value of non-current assets, which is mostly the result of a very large increase in the value attributable to Hanji. It goes up by in excess of $180 million. As a result, the profit and loss account shows a very large entry relating to the increase in value of Hanji. It does also show trading profits of some 5.7 million, plus some other figures which give rise to total profits for the year, excluding the valuation profits, of 6 million. But again, the cash flow shows a negative cash flow from trading activities, leading to net cash at the end of the year of $360,000. Now, those accounts show the investments held by Vision, and they show the shares in Hanji, but also unlisted shares worth about $200,000 and investment in properties worth $420,000, both of which are new in that accounting year. Now, dealing with the properties first, so you've got properties of 420,000 odd. From where has Vision obtained the cash to buy these properties? If it had spent its own cash, then that would be reflected in the cash flow statement. And it isn't. Indeed, there is no entry in the accounts that I've been able to identify which explains how Vision acquired those properties. Because normally, either the properties it bought with its own money, in which case it would show up in the cash flow statement, or it was the properties were given to it by somebody else, in which case it would be a capital contribution and would be reflected there, and it isn't reflected there either. So there's no accounting entry that explains how Vision got those properties. On the unquoted shares, the same point arises. Nothing in the accounts explains how these were acquired by Vision, and there would be, or there should be. But there's a more fundamental point. Mrs. Gupta's evidence is that these unquoted shares are a reference to Vision's investment in Silver Star. The problem with that is that you've got two inconsistent stories. The accounts seem to show the interest in Silver Star being acquired by means unknown for $196,800. Her asset disclosure says that it was acquired for $31.6 million. The point we make is that even if you take these accounts at face value, even if you treat every line item as gospel truth, they cannot explain how Vision acquired the assets which it ultimately came to hold from the proceeds of its own trading activities. But that in some ways is, as I say, that involves taking the accounts at face value. But there are very, very good reasons not to take them at face value. Now, as you have rightly pointed out, there are the forensic accountants have looked at this, and there is quite a lot of detail on this. I want to just highlight a couple of key points that we say are of particular importance. First of all, the starting point is that it's suggested that Vision was, from very shortly after its founding, engaging in hundreds of millions of pounds a year in metal trading. Now, Trafigura, which, as I'm sure the court is aware, knows a thing or two about metal trading and metal traders, has searched in vain for any public record of or reference to these trading activities. Hasn't found anything. Given the alleged scale of the activities, that is, to put it no higher, extremely surprising. But there are also certain features of the accounts which are remarkable to the point of, we say, being highly suspicious. The first is that Vision did not have a bank account until 2020. Now, what is said in the 2019 accounts, and I'll read this out. I don't think I need to take you to it. What is said in the 2019 accounts? Sorry, if you give me a moment. Is that there is no cash. No cash at the bank is listed. It says cash in hand, which was $470,000, is as per the management representation and without physical verification. So the auditors appear to have been told that Vision had $472,000 of cash, I don't know, hidden in a sock somewhere, but no bank account. And so the suggestion appears to be that Vision was able to engage in over 145 million of metal trading in the year to the 30th of September 2018, and over 221 million of such trading in the year to the 30th of September 2019 without a bank account. And we say that that is so absurd that even on a hearing such as this, you can draw a very powerful inference that if Vision had no bank account, it wasn't trading, either at all or in anything like the orders of magnitude suggested. The second point I want to take is that there is a glaring contradiction between the latest set of draft accounts relating to Vision, which are those for the period up to the 25th of April 2023, and the asset disclosure that Mrs. Gupta, or the disclosure of Vision's assets that Mrs. Gupta provided in May 2023. So the accounts, well, actually, I'll start with the asset disclosure. So as I said before, the asset disclosure required Mrs. Gupta to give an approximate value for her shareholding in Vision. And what she chose to do, perfectly reasonably, was do a sort of narrative version of that, which is that there were notes setting out what she said Vision's assets were. But that disclosure did not refer to or give any value to the sorts of assets you would expect a very substantial trading business to have. The most obvious category of that being trade debtors. Now, the 2023 accounts, or the 2023 draft accounts, identified trade and current trade and other receivables of just under 72.5 million, and trade and other payables of about 48.7 million. So on the basis of the draft 2023 accounts produced by Mrs. Gupta herself, Vision had an asset in the form of receivables worth over 72 million. And even if you deduct the payables, the net position is about 24 million, to which you find no reference in her asset disclosure, which is produced about a month after these draft April 2023 accounts. So there are two possible explanations of that. Either Mrs. Gupta has deliberately omitted a very important line item from her purported description of Vision's assets, or the accounts don't reflect the true position. And doubtless at trial, one could have an interesting debate about which of those were the case. But Your Excellency, we say there's a more fundamental point. I've been taking you through some of what Mrs. Gupta has provided, but it's also worth bearing in mind what she's chosen not to provide. If she wanted to show that a particular asset, such as, for example, Vision's interest in Silver Star, was purchased using Vision's trading income, then actually there should be a very simple way of doing that unequivocally. You could produce the bank statement which showed the trading income coming in and then being paid out to acquire the relevant asset. Now, Mrs. Gupta has chosen not to do that. And whenever we criticize her for it, she says she's under no obligation to do that. But that's where we come back to where we started, which is we only need to raise a triable issue. It's for Mrs. Gupta to show that our case on these points is so weak that it doesn't disclose a triable issue. If she chooses to attempt to meet that burden by producing inconclusive documentation in circumstances where she plainly could have produced conclusive documentation if it existed, then she must live with the consequences of that. And those consequences are likely to include the court being unable to determine the point summarily, and therefore deciding that Trafigura has an arguable case that Mrs. Gupta is holding assets as a nominee for Mr. Gupta, which is all we need for present purposes. Your Excellency, I was going to move on to UAE law, but I noticed the time. Would that be a convenient moment for a break for the transcriber?
Yes, all right. I think 15 minutes. All right, we're back here at 3:45 my time, whatever time it is where you are. Okay.
Thank you.
Okay, Mr. Peters.
Yes, Your Excellency, apologies. I've just received a message. Apparently, we are being asked to share our skeleton argument with third parties, members of the press, and there's an inquiry from my solicitors as to whether the court has any objection to us doing so.
I've already made a ruling, I think, on whether these would be closed proceedings or not. The skeleton
Yes,
argument.
I think that's right.
Merely a statement of your argument. I don't see any objection to that. Mr. Trotter, do you have a view?
No, no objection to that.
All right, thank you.
So, Your Excellency, I was going to proceed to deal with the second sub-issue arising under the merits of the Chabra argument, which is Mrs. Gupta's point that even if she is holding assets as a nominee for Mr. Gupta, either directly or indirectly through Vision, there is no arguable UAE law route by which we could enforce a judgment against Mr. Gupta, against her assets or Vision's assets.
You put up 3 modes of enforcement, I think.
Yes.
Okay.
Now,
It's
again,
indirect, something called Paulian, and something
yes,
called stimulated contract.
yes, indeed. And the first point I was going to make, which I can make briefly because I'm sure you have it well in mind, is that this is not the time to determine substantive disputed points of UAE law on their merits. And again, the relevant question is, do we have a good arguable case? I mean, I should say that, of course, if this were a matter proceeding under DIFC law, it would be, frankly, a no-brainer because DIFC law recognises the distinction between legal and beneficial ownership in much the same way as many common law jurisdictions. Now, I'll come to the particular actions in a moment, but the core of Mrs. Gupta's case really is the proposition that onshore UAE law doesn't recognise that distinction. And so it is possible, she would say, under UAE law, for someone in Mr. Gupta's position successfully to hide his assets from his creditors, provided that he acts with sufficient skill and or deploys a sufficiently complicated structure to do so. But perhaps unsurprisingly, that's not, we say, the correct answer. And it's certainly arguably not the correct answer. First, and perhaps most importantly, UAE law does recognise the concept of person A holding assets as a nominee for person B, and it does provide routes by which to recognise and vindicate the true position, i.e. that person B is the real owner of the assets. Now, that is apparent from Mr. Elawawi's letter, which is the first bit of the expert evidence. I have endeavoured over the break to get tab references, which may mean that I can take you to a few more documents. I don't know whether that may be welcome or unwelcome, but
well, it depends how you use them, Mr. Peters.
yes, it will certainly be less inconvenient logistically. So his letter is at bundle R1, tab 333.
Yes, this is
SH.
just make sure I've got the right one. Looks like it. Yes, Stevenson Harwood letter.
Yes, that's the right one.
Yeah. Okay, thank you.
And the key paragraph that I want to go to is paragraph 11, which is on page 4872. So it's
I've got
3 or
that,
4
thank
pages.
you.
Yeah, now I'm not going to read that out as you've got it in front of you, but he points out that a paradigm case for invocation of articles 394 and 395, which provide for the reversal of sham transactions, is where a company has nominee and true shareholders, and the latter wish to have the true position formally recognised. And that's also confirmed in the M & Co letter. And again, it's worth going to. This is just 3 tabs further on, tab 336. And I want to start.
So which tab are you after now? We're on
336, R1 336.
Oh, I see. Okay.
I'm so sorry. Could I trouble Mr. Peters to give the page references as well for my benefit? Because I'm
yes,
working from the same version of the bundle as his.
Yeah, starts at page 4900. Your Excellency, would it be helpful if I think it's a fairly short paragraph or a line, would it be helpful if I just read it out?
I've got the right one. I was just going to the wrong. It's my incompetence here. Here we are, I think.
So it's paragraph 410 of that report on page 4906. So about 6 pages in.
Yeah.
And you'll see 410. Articles 394 and 395 do not require the doctrinal recognition of beneficial ownership. They require proof by any admissible means that an apparent contract conceals a real contract. Where it is established that a registered shareholder holds shares as a nominee, the consequences under UAE law is the recognition of real ownership reflected in the hidden contract, not importation of common law equitable title. Now, applying those principles to this case, we say that the following analysis is at least arguably available under UAE law. The true position is that it has been agreed between Mr. Gupta and Mrs. Gupta that she will hold assets for him, including the shares in Vision, in her own name, but as Mr. Gupta's nominee. And that therefore she is holding assets that are in truth Mr. Gupta's, and at least potentially Vision is as well. But consistently with the passages that I've just taken you, to which I've just taken you, we say it would be open to the onshore UAE courts to recognise that Mr. Gupta is the true owner of relevant assets, including at least Villa K1 and the shares in Vision, and it could give effect to, or make orders which give effect to that reality. Now, in terms of practical enforcement from Trafigura's perspective, it is a creditor of Mr. Gupta's, because it's got a judgment for over $700 million against it. So it has standing to bring a claim under Articles 394 and 395. If Villa K1 is recognised as an asset of Mr. Gupta's, then Trafigura will be able to enforce against that asset, sell it, and apply the proceeds in satisfaction of its debt. If the shares in Vision are recognised as an asset of Mr Gupta's, then Trafigura could enforce against the shares, take control of them, liquidate the company, and access any value in its assets. Now, it has been pointed out on that by Mrs Gupta that Trafigura's ability to enforce against Vision's assets in the way I've just described would involve it ranking behind Vision's own creditors. Now, if Vision has any genuine third-party creditors, that might be right. But it's no answer to the proposition that we have a viable route to enforcement. Routes to enforcement often involve competition with other creditors, or indeed having to wait behind other creditors if they exist. And that is, in effect, Trafigura's risk to take. One other point that is taken is that we would have to prove the existence of any nominee arrangement between Mr. and Mrs. Gupta by written evidence. There are two short answers to this. The first is that it appears to be common ground that where there is fraud or circumvention of the law, that requirement does not apply. And we say that if it were established that Mr. and Mrs. Gupta had deliberately engineered a situation in which his assets were being presented as hers in order to keep them out of the reach of his creditors, then that the requirement of fraud or circumvention of the law would be satisfied. In any event, there are cases from other jurisdictions, in particular Egyptian cases, which suggest that a more relaxed view of this evidential requirement is at least arguably available, and there is at least an argument that the UAE courts should follow those cases. And on that, I'd simply refer to paragraph 112 of Mr. Trotter's skeleton, which, in fairness, accepts that those Egyptian cases indicate a more relaxed approach, and effectively says the UAE court shouldn't follow it. Well, okay, and again, a matter for trial. Now, I focused on Articles 394 to 395 because the reality is the other potential causes of action ultimately give rise to the same arguments. So take the indirect action under 392 to 393. That involves the creditor, Trafigura, exercising rights vested in the debtor, Mr. Gupta. Now, if Mrs. Gupta is holding assets as a nominee for Mr. Gupta, he has a right to call on her to return those assets, and that is a right which Trafigura can exercise in his stead. So in other words, it all boils down to the same thing. If we are able to establish a nominee relationship between Mr. and Mrs. Gupta in relation to certain assets, then UAE law, as I said at the outset, provides multiple different ways of reflecting the true position. And it's not surprising that that's the case, because otherwise it would be very, very easy for fraudsters such as Mr. Gupta to hide assets from their creditors in a way that the creditors would find it very difficult to unwind if those assets were in the UAE.
Now, it doesn't matter for the purposes of UAE law whether a nominee relationship would give rise to a trust under the common law, under the principles of equity.
No, in many ways, it's one of those things where I suspect the difference between the common law approach and the UAE law approach may be more apparent than real. We have a very developed notion of beneficial ownership and trust. And although we use the word nominee from time to time, it's not really a term of art. It tends to reflect situations where you would find a trust or something similar to a trust.
Well, they claim to have invented the trust 500 years before England in a thing called the Waka.
Exactly. But the point is this, which is that ultimately, and perhaps unsurprisingly, advanced legal systems have mechanisms for avoiding things like a person in Mr. Gupta's position shunting all his assets to someone else and then claiming that they aren't his. So, Your Excellency, that's what
you can characterize it. You can characterize it in a couple of ways, I suppose. You can say that the apparent ownership of somebody is a pretense. You know, say I own this house, when in fact the title has never been transferred. I'm not quite sure how does the notion of nominee, what are the legal relationships between nominator and nominee of a piece of property?
I mean, I think the answer is that a nominee is someone who is holding the asset. It's a very similar, it's why I say it tends to be on the common law side, something we use perhaps more as a piece of invective than a term of art. It describes someone who is holding an asset subject to the nominor's instructions and subject to an obligation to do whatever the nominor wants, including return the asset to them if they want.
Do they have an apparent, will they have a legal title? Do they have to have a legal title, or they just have to have possession of an asset or control of an asset?
I suspect they could just have possession, or I suspect it could be either. I don't think it matters for present purposes.
Yeah, I don't want to lead you down a rabbit hole.
That's what I was going to say about the merits of the Chabra application. So now I wanted to deal with certainly where I think Your Excellency started, which is why we say the particular variations to the DIFC Chabra order that we're seeking are justified. So again, just to summarize, we say in some ways this is quite simple. Mrs. Gupta has repeatedly breached the orders of this court and indeed of other courts. In particular, she has managed to subvert the notification requirements which currently exist so as to dissipate an asset, namely Villa KO3, which is an asset of very substantial value, and she has dissipated it, as it were, out from underneath the protections that are supposed to be embodied in the DIFC Chabra order. And a more restrictive regime is therefore necessary and appropriate, and there is no good reason to consider that the imposition of that regime would be unduly prejudicial to Mrs. Gupta. So obviously the predicate for all of that are breaches of the of various court orders. I should say also, Your Excellency, I am running ahead of time, if that persists. I will, I think I had budgeted in the, certainly for my own purposes, that I'd be between 2.5 and 3 hours, and I will certainly be done by lunchtime, probably be done materially before lunchtime, just so you have an idea of where we're going.
Yeah, the complexity can be a bit beguiling. The headline issues are really a bit more simply stated, I think.
Well, I heartily agree. One does have to delve into the detail sometimes, but I'm always grateful to be hoiked out of it. So breaches of the original Chabra order, and here we rely on Mrs. Gupta's dealings with Villa K3. Now, it's not disputed that that villa was subject to the notification requirements. So perhaps if we could start, what is Mrs. Gupta's evidence as to what actually happened? So she says that in January 2025, she guaranteed payment of a sum of over 15 million said to be due from Vision to a third party called Sharp Trend. And on the 2nd of April 2025, she entered into a settlement agreement under which she agreed and Vision agreed actively to market for sale Villa K3 and certain other properties, namely units within what is known as Platinum Towers. And the settlement provided that her obligation under the guarantee would be discharged by remitting the proceeds of sale from whichever property sold first to an entity called Al Noor, said to be Sharp Trend's debt collection agent. So as at April 2025, Villa K3 was being actively marketed for sale and was hypothecated to repayment of a debt which Mrs. Gupta says she owed personally to Sharp Trend. Now, a contract to sell the villa was concluded on the 28th of October 2025 with a deposit, a 10% deposit of 2.225 million dirhams being paid on that day. And that is apparent from the terms of the contract itself, which for your note is a bundle M tab 222. I don't think we need to go to it. Now, we say the reasonable inference is that terms had been negotiated and had been agreed sometime before that, i.e. before the 28th of October. So if you accept that story entirely, where does it leave you in terms of Mrs. Gupta's compliance with the DIFC Chabra order? Well, the conclusion of a binding contract to sell Villa K3 on October 28th of October 2026, together with the payment of a deposit pursuant to that contract on that date, we say was obviously a dealing with or a disposition of Villa K3. So what notice was given? And I think it is worth us going to the notice. So in the tab, it's tab K119, and it's page 2161.
Now, when you say K119, there's a sub-tab, there's K1, 2, 3, 4, etc.
Oh. If you give me a second.
This is under the heading Inter-Solicitor and DIFC Court Correspondence.
Yes, that's the right heading, but I've got a version. I was sent over the break a version of the index, which has a continuous set of tab numbers running from 1 to 400. Are you saying that your version is numbered from 1?
Yeah, well, what we have a number of alphabetical tabs, and within each alphabetical tab, there's a numerical series running from 1 to something.
Okay. If you give me 1 second, I'll be able to give you the number.
Yep.
I think if it assists Mr. Peters, it might be K23.
I'm very grateful.
Yes, this is Larson, UK.
Larson, UK, letter of the 26th of October, 2025.
Yes.
So, first of all, it was served on the 26th of October, 2025, so about 48 hours before the relevant dealing. We say that the description of the commercial purpose of the sale of Villa K3 was so vague as to be meaningless, and we note that that is a proposition with which His Excellency Judge Cook wholeheartedly agreed in his ruling on our urgent application. But even vague as they were, the explanations given in this letter were, on Mrs. Gupta's current evidence, false. So if we look at the paragraph, fourth paragraph down, I am instructed that Villa 3 is being sold in order to realise funds for the operation and or maintenance of assets and to comply with clause 4.2 of the order, which requires Mrs. Gupta not to diminish the value of her shareholdings in Vision Limited. Well, we respond to that. No, it wasn't. It was being used to repay a trade debt which had been personally guaranteed by Mrs. Gupta, and the overall effect of the transaction, as described, would be to increase the value of Vision's shares whilst decreasing the value of Mrs. Gupta's assets. But worse still is the final paragraph, which says, Ms. Gupta further confirms that the proceeds of sale will be applied in accordance with Clause 2 of Schedule C, including, without limitation, to meet ordinary living expenses, reasonable legal costs, and all the costs of maintaining or operating the excluded assets. Now, as we observed in writing, on Mrs. Gupta's current evidence, that paragraph was untrue, and she must have known that it was untrue when she instructed her solicitors to write in those terms. She now says that all the proceeds of sale went straight to Al Noor to repay Sharp Trend, and that she never saw a cent. So it was simply inconceivable that any part of the proceeds would be used to pay her legal or living expenses. Also, the description of that payment as maintaining or operating the excluded assets, i.e. the other properties owned by Vision, is not a legitimate description of what Mrs. Gupta now claims to have happened. Now, we say there are only two possible explanations for this. First, that Mrs. Gupta instructed her solicitors to produce a notification that she knew to be false. Second, that the false story is the one that she's now peddling, i.e. the story that the Sharp Trend debt about the settlement and the payment being routed through Al Noor. Now, we do say that there are a litany of points which suggest that the latter explanation is the correct one. And of course, if we're right about that, a significant part of Mrs. Gupta's case on this application is a deliberate fraud by her on the court. Now, that is a serious allegation, but we say it is justified by a number of features of her current story. First, as I have already explained, there are reasons why the court should harbour grave doubts over her evidence of Vision having any substantial trading business. And of course, if Vision didn't have any such business, that would, without more, fatally undermine the suggestion that there was ever any genuine trade debt, still less a trade debt of some $15 million. Second, there is the position in relation to documentation which Mrs. Gupta has produced in relation to her Vision's dealings with Sharptrend. In essence, she's produced some documents said to evidence the underlying dealings, including an invoice and bills of lading. Given the history of this matter, which includes Mr. Gupta successfully defrauding Trafigura by producing forged commercial documentation on a grand scale, we are understandably suspicious of that type of documentation, particularly where it is produced late in the day. We therefore sought and were granted an order requiring Mrs. Gupta to produce native electronic copies with metadata of her personal guarantee and the invoice from Sharptrend, because that would have shown when they were produced. She's not done that, and in fairness to her, she says that she can't. However, we do say if these dealings were genuine, there ought to be a litany of contemporaneous electronic material, which, if it existed, would establish beyond doubt the truth of the account that she now gives. And she's chosen not to produce that documentation. Again, it's a situation in which documentation that would put the matter beyond doubt could have been produced if it existed and hasn't been. Our third point under this heading is that there is a series of commercial absurdities in relation to the alleged guarantee and the alleged settlement agreement. Now, Your Excellency, I've dealt with this in some detail at paragraph 54.3 of our skeleton, so I can summarise. The guarantee, which is what exposed Mrs. Gupta to the relevant liability, is a thoroughly uncommercial agreement for her to have entered into. It involved her personally accepting liability after the transaction, so not in order to persuade Sharptrend to deal with Vision, but ex post facto, for a debt of over $15.5 million, payment of which would have entailed personal ruin for her if she were ever called to pay all of it. In return, all she got was Sharptrend promising to delay enforcement action against Vision for 2 months. An expensive 2 months, one might think. Having obtained the guarantee, Sharptrend's conduct in entering into the settlement agreement was then uncommercial in precisely the opposite direction. At that point, it had no need or reason to waive the majority of its debt, especially in circumstances where the settlement agreement required properties to be marketed for sale, which, if they all sold, would have raised 50 million dirhams. That's about $13.6 million. So rather than simply saying, well, you owe me $15 million, you're personally on the hook, Mrs. Gupta, sell those properties and pay me the whole lot, it agreed to receive a sum of, in the end, less than $5 million. Sorry, slightly more than about $5 million, or a third of its debt. Fourth, there are some really profound oddities about the process of sale for Villa K3. Again, we've dealt with this in writing. It's paragraph 53 of our skeleton, so I can summarise. Mrs. Gupta's evidence as to when and how the seller paid for Villa K3 doesn't marry up with the sale contract. In particular, the sale contract records a deposit of 2.225 million being paid by cheque in favour of the seller simultaneously with signing of the sale contract. That is on the 28th of October. Indeed, the sale contract even identifies the cheque number of the deposit cheque. And then it required the balance to be paid by what referred to as a manager cheque in favour, again, of the seller. Mrs. Gupta's evidence is that payment was made via a series of cheques, none of which was dated 28th of October. Indeed, they all date from, I believe the first one is the 31st of October. none of which was in the deposit sum of 2.225 million dirhams, none of which bear the check number which the contract specified in relation to the deposit check, and none of which were drawn in favour of the seller. And just for your note, the reference to that evidence is paragraph 20 of her third witness statement. We also say that the manner of payment identified by Mrs. Gupta, that is, by check to someone who's neither the seller nor the seller's agent, but an agent of a third-party creditor of the seller, is an extraordinary way to have proceeded with a property sale of this type. It's very hard to see how the purchaser could be sufficiently confident that payment made in that way would in fact result in a good discharge of their contractual obligation to pay, particularly when payment by that means would be positively inconsistent with the contractual terms governing the sale of the property. Now, the fact that payment was made to Al Noor is, for Mrs. Gupta's purposes in relation to this application, rather convenient. And we say suspiciously convenient, because it means that she can claim to be unable to produce any documentation actually showing where the proceeds of sale went, and in particular any documentation confirming that they did actually go to Sharp Trend. Now, if that were not worrying enough, and we say it is more than worrying enough, the role of Al Noor is concerning. In the settlement agreement, it is identified as being a debt recovery agent. However, Trafigura has recently uncovered documentation which suggests that that description is at best inapt, and that Al Noor is a commercial associate of the very entity which has been funding Mrs. Gupta's legal fees in relation to these proceedings, and which has also been funding Mr. Gupta's legal fees. So we get that from a Form 6K that is towards the end of the bundle. So it's bundle T. It'll be bundle T tab 2, I think.
Yes.
So you should have United States SEC Form 6K relating to Diginex Limited.
Yes,
the key paragraph, if you go over the page to 7972.
Yep.
And it's probably easiest, Your Excellency, if you could read the first paragraph to yourself.
Okay, thank you. Yes, okay.
Yeah. So Al Noor and Nomas is the entity which is the alleged funder, are working together on this transaction with Diginex. Now that is, given the litany of other oddities about this Sharp Trend transaction and the sale of Villa K3, it is, to put it mildly, extremely concerning that there appears to be this connection between the person to whom the sale proceeds of Villa K3 were paid and the person funding Mrs. Gupta's legal fees. And that concern is magnified by the discrete oddities surrounding Nomas's position as a funder. Now, I'll address that further at the end of our submissions in relation to the funding disclosure application. But the key points are, as far as we are aware, Nomas is not an entity that's in the business of litigation funding generally. It's not Burford Capital or something like that. its funding of the Gupta's legal fees is not something which would be countenanced by a professional litigation funder. Indeed, we say it looks thoroughly uncommercial. And we, as I say, we now find it doing business with the entity to whom, the persons to whom the proceeds of sale of Villa K3, conducted in breach of the DIFC Chabra order, have been paid. And in circumstances where I've already described, that sale itself was highly anomalous. So, drawing the threads together on Villa K3, we say that even if the court were to swallow Mrs. Gupta's story about the sharp trend debt, she's guilty of serious breaches of the DIFC Chabra order. And of course, if the court refuses to swallow that story, as we say it should, then the matter is, of course, exponentially worse for her. Next, and briefly, I want to address breach of His Excellency Judge Cook's order. That is tab D. Section D, tab 9, I believe. Page 1271.
Yes.
And at page 1271, you have paragraph 4 of that order, which required various things to be done within 6 hours of service of the order. So it required various information to be given regarding the sale, including who received the proceeds, where they'd been paid, the intended use of the proceeds. And then over the page at 1272 at paragraph 4C, if Villa K3 has been sold, produce any documents within the second respondent's control from the Dubai Land Department relating to the sale, etc. Now, Mrs. Gupta ignored this order, and she did so for months. In her second witness statement, which is dated the 5th of January 2026, she provided some but not all of the information required, and she did not provide any of the documentation required. She then purported to cure that by her third witness statement, dated the 17th of February 2026, more than 3 months after His Excellency Judge Cook's order. Now, although Mrs. Gupta has apologised for that breach, she has provided no excuse for it. The fact is, she simply ignored that order, and she ignored it for months. The final, we say, relevant breach of court orders is it's actually a breach of the English order. But we say it is relevant for reasons that I hope will become apparent. This concerned what have been referred to in the papers as the Discovery Gardens apartments, which were in fact sold on the 3rd of June and the 18th of July 2024. But Trafigura did not realise that they had been sold until Mrs. Gupta confirmed the position in Gupta 4, which was served on the 31st of March 2026, nearly 2 years later. Given that those apartments had been subject to the English Chabra order since April 2023 and were expressly identified in the DIFC Chabra order because we didn't know they'd been sold, that is pretty extraordinary. In relation to her attempts to comply with the English order, she served a purported notice under Schedule C of that order in relation to the 2 apartments that were sold on the 4th of June, and she did so on the 28th of May 2024. The notice indicated an intention to deal with those apartments at an unspecified future date and promised details of amounts incurred and to be paid out of the proceeds, and confirmation of the sale price when buyer is identified. Perhaps unsurprisingly, given the history, the promised updates and confirmations were never provided, which was itself a breach of the English order, because no notice was ever provided of what Vision was to receive pursuant to these sales. In any event, the sales completed a week later, that is a week after the notice, which strongly suggests that the matter was much less speculative than the notice that was served had indicated, and that in all probability a purchaser and a price had already been identified and could have been identified in the notice and wasn't. In relation to the further discovery garden apartment that was sold in July, Mrs. Gupta has no record of any notice being given, and nor do we. We invite the court to conclude that none was served, and that is yet another breach of the regime set out in the English Chabra order, which on this point contains restrictions in the same terms as the DIFC Chabra order. And that is relevant because it is an indication of the extent to which this form of restrictions isn't working, because it isn't being complied with. Given that history, we do say that it is not practicable to think that there is some other higher form of notification requirement that will work, because you have a mixture of bare minimum compliance with the notification, well, perceived by Mrs. Gupta as being bare minimum compliance with the notification requirements, which in fact amount to non-compliance in some instances. In other instances, simply failing to comply, simply ignoring the notification requirements and not giving a notice at all. And in other instances, giving notifications that are demonstrably false. And we say that you consider that collectively, and in effect, Mrs. Gupta has, by her own conduct, created a position where she cannot be trusted to comply with any set of notification requirements in a way that adequately protects Trafigura's position. And that the correct course is therefore that there should be an unqualified freezing order. And if she wants to do something with the assets, she should have to come to court and provide a proper, coherent explanation of what and why. And that raises the question of prejudice. Well, in terms of prejudice to Trafigura, the prejudice is, as I've just described, the current notification regime is demonstrably not working. Properties have been disposed of, in at least one instance, in highly suspicious circumstances, without the notification provisions being complied with. And just to give you an idea of how it works, if a proper explanation of the whole sharp trend story had been provided before Villa K3 was sold, then Trafigura could have stopped that sale going ahead and demanded explanations and answers to all the queries and all the implausibilities that I've just identified. And if Mrs. Gupta couldn't satisfactorily deal with those points, the sale would not have been able to go ahead. And she would still be holding Villa K3, which is a $5 million plus asset. So as we say, the fair solution is an unqualified order, which effectively reverses the burden of applying to court. So whereas before it was us to stop dispositions, going forward, it would be for Mrs. Gupta to persuade us or this court as to the legitimacy of any proposed disposition. We struggle to see how Mrs. Gupta can contend that that increase of the level of protection for us will meaningfully prejudice her. Villa K1 is her home, and she has not indicated any intention to move out of it or to sell it. And if such an intention forms for a legitimate purpose, then it can be the subject of discussions with Trafigura or an application to the court. Her current position in relation to Vision and we are talking about an order that first of all freezes the shares in Vision directly and prevents her from procuring Vision's dealing with the relevant assets. But her position is that her shareholding in Vision is worth nothing. But if there is some transaction in the future with its assets, which would be in her or its interests, then she would still be at liberty to apply again to approach us for agreement or the court for permission. So the balance of prejudice, we say, falls overwhelmingly in favour of granting the order that we seek. Finally, on discretion on the variation application, I want to deal with some elements of Mrs. Gupta's case about Trafigura's conduct, because her skeleton is laced with tendentiously framed criticisms of Trafigura's conduct, particularly in relation to proceedings onshore in the UAE. And we do say that none of those criticisms stand up to analysis. The first and perhaps most important criticism is that we have no intention of enforcing our judgment against Mr. Gupta, against Mrs. Gupta's assets in the UAE via the UAE law routes that we have identified. And they say you can tell that we have no intention of doing that because we haven't taken steps to do so. Now, that is a thoroughly bad point, and it is based on a pretty basic misunderstanding of what onshore enforcement would entail and what it requires. The logical predicate of all the UAE enforcement routes, which I addressed earlier and which you've seen in the evidence, is that Trafigura is a creditor of Mr. Gupta. That would require Trafigura to enforce its judgment against Mr. Gupta in the UAE. But of course, before we could do that, we had to obtain judgment on our claims against him, which we did on the 26th of February this year. Also, we couldn't commence onshore enforcement proceedings for so long as there's any outstanding appeal against that judgment in England and Wales. And an application for permission to appeal was outstanding until it was dismissed by the English Court of Appeal on the 22nd of May this year. So when it is suggested in Malone & Friends' skeleton that we've had 18 months to take steps to enforce in the way we envisage in the UAE, I am afraid he is simply talking nonsense. I should say, as it happens, what we have done is to commence enforcement proceedings in the DIFC, because we were able to commence those whilst Mr. Gupta's application for permission to appeal was outstanding. And it is certainly our hope that obtaining an enforcement order in the DIFC in the first instance will ultimately represent the quickest and most efficient way of establishing our status as a creditor for the purpose of any enforcement action against relevant assets held by Mrs. Gupta in the UAE. So the allegation of jurisdictional arbitrage is based on a false premise. I have to say, I don't understand the submission in any event. The relevant UAE rules and procedures are what they are. We can get such orders in light of the orders we've obtained here and the orders we've obtained in England. We can or can't get whatever orders the UAE legal provisions say we can or can't get. Now, we accept that one feature of the system is that DIFC orders may be more convenient to enforce, maybe more readily enforceable onshore than other foreign court orders. And there may therefore be some procedural benefit to us obtaining DIFC orders. We've always been completely open about that. For example, if you look at the skeleton that we filed in support of our original application for the DIFC Chabra order, we referred repeatedly to the intention that that order would be a useful and productive way of protecting our position onshore. I should say, it's also important to note that if this court is persuaded that we should have the benefit of an unqualified freezing order over the remaining assets identified in the DIFC Chabra order, it's very hard to see what possible objection there could be from the perspective of this court to Trafigura obtaining such onshore relief as might be necessary to make sure that order is complied with. That would simply aid policing and enforcement of the DIFC order, which one would expect this court would regard as a good thing. And whether and to what extent the onshore courts are prepared to make orders with that effect is a matter for them. I should say Mrs. Gupta complains about certain particular injustices that have been inflicted on her. She refers to her bank account being driven to a negative balance of 2 billion dirhams and an inability to sell her car to meet expenses. The short answer to that is that these are not things we've asked the onshore courts to do, or any third party to do. And they're not things that would be made any worse if you grant the variation sought, or made any better if you don't. They are completely irrelevant. They are matters which Mrs. Gupta is at liberty to raise with the onshore courts, and given the amount she must be spending on these proceedings, one can reasonably infer that that's something she would be able to do. But as I say, it really has nothing at all to do with the merits of granting an unqualified freezing order over the relevant assets. And as I've explained, we say that the case for such an order is compelling. So, Your Excellency, those are my submissions on the variation application. I was now proposing to hand over to Mr. Macpherson to deal with the discharge application.
Thank you. Yes, Mr. Macpherson.
Thank you, Your Excellency. I will endeavour to give the correct cross-references to your tab labelling system, which I have intended to update. Your Excellency, I'm mindful that you've referred to the voluminous evidence. You'll be aware that the discharge application is dealt with by an application notice supported by a witness statement from Mr. Fedrigoli, his first witness statement, and then a very lengthy responsive witness statement from Mr. Will, his first witness statement, where he deals comprehensively with the complaints that are made, the alleged breaches of full and frank disclosure. So I don't intend to descend to every particular of those detailed grounds. What I intend to do is to take the charge sheet, if I can call it that, as the annex to my learned friend Mr. Trotter's skeleton argument, which is 4 pages. And that helpfully summarises what I take to be the complaints that are pursued for the purposes of the discharge application.
What do you say is the guiding principle for what you have to disclose?
What do I say is the guiding principle?
Yes.
Well, what we say, what we accept, although I'll have something to say about this in terms of the context, but what we accept is that there was a duty to give full and frank disclosure, albeit not one that arose in a without notice context, but in the context of a short notice hearing. We were, in accordance with the principles which are well known and set out in the Tugashev authority, we were under that duty. But there are important qualifications to the duty in the particular context of this case, which I will develop. But one point I would make at the outset, which is relevant, which is that we're not expected to disclose matters that we could have had no reasonable apprehension were going to be raised. And that is squarely relevant to the Chabra point that is now being taken. And for all the reasons that my learned friend, Mr. Peters, has developed, that was not a point that was ever live, ever intimated. And so not one that we could reasonably be expected to have raised. But as I say, we do accept that there was a duty. We're not resiling from that, and I'll explain in due course why we fully complied with it. But let me, if I may, just explain the structure of my submissions. I'm going to make a few headline points to start with. Secondly, I will deal with the relevant factual background as rapidly as I can. I was going to say something about the legal principles, but probably very little indeed, and possibly nothing at all. Fourthly, I'll then focus on the alleged breaches in the annex to Mr. Trotter's skeleton, and then finally deal with the appropriate relief. There are four headline points. First, there is an unusual context to the allegation of the breach of full and frank disclosure. This is a circumstance which is really far removed from the typical situation where a respondent is on no notice of a hearing, first hears of it after the fact when they're served with the order. It's not even a case where you have a short notice hearing where informal notice is given of the hearing the night before, and opposing counsel has no proper opportunity to prepare, but they attend nonetheless. Those are qualitatively distinctive situations. This is a situation where the defendants were on notice of the hearing from the get-go. The urgent application on the 31st of October was seeking the same relief as the variation application on the 21st of October, which they were served on, which was served on the defendants, but it was sought on an urgent basis, and they were aware of the variation application since the 21st of October. They actively participated in correspondence in the days leading up to the urgent application, as we've seen. They were served with the urgent application on the 31st of October. They served witness statements on the 3rd of November. They served a skeleton argument on the 4th of November. They then chose not to attend the hearing. Now, that was their own decision. They've never explained it. The inference is that it was a deliberate decision not to attend because they'd already sold the asset whose sale Trafigura was seeking to restrain, and they didn't wish to be accountable to the court for breaching the DIFC order. They've now sought to profit from their non-attendance by alleging that we were subject to a full and frank duty. And as we pointed out in our skeleton argument, if the hearing had been held less than 24 hours later, there'd be no duty of any kind, and no application could have been made. So we accept we're subject to a duty, but we also say that it has to be interpreted in that context I've just described. And what the cases say is that the whole rationale of the duty is to protect the ability of a party to put all the relevant legal and factual information before the court. The defendants had that opportunity and they availed themselves of it. They served a skeleton, they served witness statements, and not to attend was their own choice. And so all of that, we say, informs the attitude this court should take to the duty on these facts. But the second point is by way of headline, is materiality. The risk that Trafigura was seeking to protect against when they made the urgent application was the sale of Villa K3. That the requirement for interim relief became apparent only after Trafigura had issued the variation application on the 21st of October. So for the purposes of materiality, the only relevant period is the 21st of October to the 5th of November. And there are long passages you will have seen from Mr. Fedrigoli's first witness statement devoted to a detailed exegesis of the history and how this matter was presented in relation to the English proceedings and so on. Well, there's no substance to any of those criticisms. But the broader point is that this type of archaeological excavation of the case's origins is irrelevant. Long ago events were not material to Justice Cook's decision. Once the 21st of October guillotine comes down, many of the second defendant's complaints simply fail as a matter of chronology because they're not material. The third headline point is the general indictment, of which you'll be well aware, that these types of discharge applications should not adopt a kitchen sink approach. And that's exactly what's happened here, that there's no attempt to distinguish points that really matter. They've thrown everything in, and they've done so in a way which effectively relies on parsing of the language of witness statements and skeleton arguments for hidden meanings. And that is precisely the sort of trawl that was deprecated by the English Court of Appeal in the Mex Group case. And so we say that the sheer number of unfocused allegations actually detracts from the discharge application. It doesn't add to it and shows the paucity of the grounds advanced. And the final headline point is to note what isn't criticised. The impression you may have gained from what I've just said is that Mr. Trotter criticises everything that we say, but of course that's not true. What is especially striking is that no criticism is made of the main basis on which relief was sought and granted. The second defendant's position in the lead up to the issue of the urgent application and afterwards in evidence was that its obligations under the DIFC freezing order had been suspended by the filing of the application with the Conflict of Jurisdictions Tribunal. And that position was one that the second defendant did not resile from, and that position alone amply justified the grant of interim relief. And once that's appreciated, and it certainly was a matter that was appreciated by Justice Cook, all of the other complaints fall by the wayside. But as I will explain, they're without substance anyway. I do want to develop the relevant factual context, just so Your Excellency understands the circumstances, both in which the duty is said to arise, but also what happened at the 5th of November hearing. As I've said, nothing before the 21st of October matters. Nothing before then crosses the materiality threshold. The starting point is the 21st of October variation application notice. Now, I don't need to take you to it, but the relief that was sought, is sought, in that application notice was that the second defendant must not deal with or dispose of any of the Schedule D assets unless and until Trafigura agrees or the court orders otherwise. So that was relief that was sought to bar any dealing with the Schedule D assets. And of course, that is the relief that we're seeking today. And that was served on the defendants. The very next day, the defendants then make their application to the Conflict of Jurisdiction Tribunal, and they seek relief, cancelling, that's the word that is used in the translated version, cancelling the DIFC freezing order. The next stage is the notice, the 26th of October notice that Mr. Peters took your lordship to. That's the letter from Larson. I don't need to go to that. Then on the 28th of October, we have, as you know, the sale contract, the Form F sale contract. Well, that, of course, wasn't disclosed to us, but it's relevant to note that that then happened next. And then we have a letter from Stevenson Harwood Dubai. And if we could just go to that, that is at Bundle K, tab 25. And you'll see that if Your Excellency has it, that's a letter actually addressed from Stevenson Harwood to Mr. and Mrs. Gupta. And it references the Schedule C notice, which is the Larson letter. And then at paragraph 7 on the second page, you'll see that a series of requests are made for further clarification in respect of the proposed sale of Villa K3. And notably at 7.2, information about the proposed purpose for which Mrs. Gupta intends to use the sale proceeds. And then 7.4, an explanation of the intended use of the proceeds. So those responses are urgently requested by noon the following day. And what we have then is an email this is tab 28, an email from the address legal@visioninvestmentslimited.com. That's the Gupta's address. And you'll see what they say. It's a very short email. It doesn't make any attempt to address the questions. And it says in the third paragraph that they are, because of the jurisdiction CJT application, under no obligation to provide the notifications sought in your letter. So that is their position at that point. And then what happens next is that we file our application. We explain in the meantime why the stay argument is totally flawed. I don't need to go to that. But then we file our application. And then immediately after that, this is at tab 31, and this is a matter of 15 minutes after that, we get an email from the same address, legal@visioninvestments Limited, where they maintain the same position. And you'll see what they say if you've got it. It says, as advised by our UAE counsel, so they're in receipt of legal advice, same position, we are under no obligation to provide the notification sought. But they then go on to provide certain information, information which we go on to criticize. And the essential complaint, Your Excellency, you can read it for yourself, but the essential complaint is this is totally vague, and it uses weasel words such as sold towards the costs for operating and/or maintaining, mainly as required, which really appearing to create some kind of latitude for non-compliance or defending what happens next. But on any view, it doesn't provide a reasonable summary of what's going to happen. But what it does say on the second page at 4D, you'll see 4D, what respondent is to receive pursuant to it, proceeds from sale for operating and/or maintaining assets. Now, as we've seen, if the sharp trend story is correct, that was also false, because she wasn't going to receive the proceeds. And then in the paragraph that follows after that, we've got the same non-limiting language, including but not limited to ordinary living expenses, etc. And of course, that, as we know, is false in what it identifies. But it's got those that carve out, which again we made clear was objectionable. But they say that is a formal notice. They maintain that position, and then what happens next is they serve their evidence on the 3rd of November, and effectively in her evidence, Mrs. Gupta takes 2 points: that she's got no obligation, as she's explained in correspondence, but secondly, she has provided all the information required by that email that we've just looked at. But importantly, what she says is that position that she takes is based on legal advice from a UAE solicitor. So she is presenting a position that is that has the benefit of legal advice. The next piece in the chronology is then the skeletons, and just briefly to show you what that involved. The Trafigura's skeleton for the urgent application is at D6. And Your Excellency will be able to read that for yourself. But essentially, just scrolling down, if you're able to do that.
Yes,
because criticism is made of the way it was presented, and in particular that we didn't fairly present the nature of the obligations and the breaches of them, the alleged breaches of them. that we were contending had happened. And at paragraph 29 of the skeleton, we explain the Shabra aspect of the DIFC freezing order, and we explain the structure of that in some detail, including at subparagraph 5, the nature of the Schedule D obligations. There's then, from paragraph 30, a detailed account of what happened in the DIFC in terms of asset disclosure and purported notices served pursuant to the DIFC freezing order under Schedule D. And that continues until paragraph 50 with the service of witness statements. And then in section C, we deal with the application, and we explain, because a point is made about this, we explain that we are seeking to enlarge the scope of the relief, because what had happened originally is that we had sought simply a blocking order in respect of Villa K3, but the repeated assertion that they were not bound caused us to expand the relief to all Schedule D assets. And so that's what that explains. And then in 63 to 64, you'll see that there is then a detailed account given of the breaches of the order that we allege. And in particular, I'd invite you to look at 63.3, which is dealing with the defective notice and the respects in which the notice in respect of Villa K3 was defective. All points that we maintained at the hearing. And you'll see at 64 then, the punchline is the information provided is vague and general and entirely uncorroborated by documentary support. So that was the position we were taking. And then at 66, we address risk of dissipation and provide detailed particulars supporting the risk of dissipation. On the other side, we have the defendant's skeleton, and that is that is at tab 7 of D. Now, my learned friend, Mr. Trotter, describes this as a haphazard document in his skeleton. It's nothing of the sort. It's short, that's true, but it's also focused and clear. And it makes 3 essential points. The first is, and this is paragraph 7 and 10, that the defendant's obligation to notify was stayed by virtue of the CJT application. The second is that they had complied with the information requirements under the DIFC freezing order. That's paragraphs 8 and 9. And the third is that they had also offered to provide further information. And that's paragraphs 8, 9, and 12. And of course, there's no mention at all of Trafigura being required to establish a Chabra basis for the relief they're seeking. So then we come to the skeleton, the transcript and the hearing, and the transcript of the hearing is in the next tab at tab 8. And I'll just briefly summarize. I don't think we'll need to turn up the transcript much, if at all, but the background to this, of course, is that when we got to the hearing, we were expecting the defendants to attend, and they filed an evidence, they filed a skeleton. There'd been no email to the court explaining their non-attendance, so we were taken by surprise. And that is the context in which Justice Cook said to me, let's proceed on the basis they're unrepresented, and you have.
You've frozen, Mr. McPherson. Can someone communicate with Mr. McPherson and tell him he's frozen?
Yes, I'll message him.
Okay.
the message has gone through. So hopefully, Mr. McPherson will see it shortly. It may be, Your Excellency, we can't get him back in very short order, given that we are very close to what I think is lunchtime for the court, that we may.
Well, it's not lunchtime for me, it's dinner time, I think, but I'm happy to keep soldiering on. Where are you located?
I'm in London, so it's mid-morning for me. I think in any event we would need a. My understanding is that we were going to break for an hour at what would normally be lunchtime.
Oh, I don't have to, but it's a matter for. Let's see, how much longer does Mr. McPherson have to go, do you think?
I think he said he was going to be about an hour, give or take. I think he's been about half an hour.
There's just so much you could say about this particular. I mean, it's a question of characterization of the correctness of the allegations and characterization. Well,
can I suggest to give the transcript? Can I suggest this? Your
I was about to
give
do
the transcript writers a break, but also not sit too late for your.
I'm not worried. I'm not worried about sitting late. I'm keen to use all the time that we have, and if we can give the transcript, there he is. He's come to life. Mr. McPherson, can you hear us?
I can. I'm very sorry about that. I don't know what's happened. I appear to have lost internet, although my pupil, who's in the same room with me, hasn't. So it's a mystery. But I'm on my phone, so I hope you can hear me, Your Excellency.
We can hear you quite clearly. If you like, we can take a short break now and give you time to regularize your appearance, and then come back. So maybe we'll make it.
I suggest that we take the hour that the court would normally take for lunch, and that will should give ample time to sort out IT problems and.
Yeah, I'm not madly enthusiastic about it now. Why don't we take? This is like an auction.
Yeah.
we will take half an hour and no more. I'm keen to make the best possible use of the time that we can, as long as people aren't sort of hanging out for food or something in London. Okay, all right. We'll come back at 5:15 my time.
Sorry, half past.
Oh, 5:30. Yes, all right, 5:30. Yes. Okay. Righto. Thank you.
Thank you.
Okay, Mr. McPherson, you appear to be regular.
Indeed, I am, and I'm fingers crossed that I don't disappear again.
Okay.
Your Excellency, we were in the transcript for the 5th of November hearing,
Yes.
and that's at section D, tab 8. And I was proposing just to take you through what happened. And I'd got to the sequence on page 3 where Justice Cook made clear that I was subject to the professional duty of full and frank disclosure. And then you'll see, if you scroll down to page 5 of the transcript, that I say at lines 11 to 15 that on the full and frank disclosure point, I think it's right to say 3 objections to the grant of interim relief have been raised in the witness evidence and skeleton arguments. And then on page 6 that I'm proposing to focus my submissions on dealing with those points. Of course, I make no apology for approaching it in that way, because those were precisely the points which the defendants, acting on legal advice, had sought to raise. Then there's a discussion over the next few pages of the order, both the relief we were seeking, but also Schedule D and what it provided. And you'll see that that discussion concludes on page 10, lines 14 to 21, where I explain Schedule D. and say the essential point is, and the whole premise of this application is that we're not being told what we should be being told, and we don't have any confidence that the respondent intends to comply or regards herself as bound by the order. Then I explain from page 12 the reasons for interim relief, and in summary, that was the lack of information, the fact that the existing notification regime was not working, and there's a cross-reference to paragraph 63 of my skeleton, which I took you to. And then the third point, and this is on page 13, lines 12 to 16, is that we had concrete escalating levels of concerns related to the response to the variation application. And again, I cross-referred the judge to my skeleton at paragraphs 41 to 50. I then deal with risk of dissipation at page 15. And then page 15, lines 10 to 12, I say that I'm going to focus on the three defences that have been raised in the respondent's documents. And of course, as I've said, the first defence was the stay argument. Now, I don't need to go into any detail on that. That was the main bone of contention at this hearing. But it's not a point that's being pursued. But what happened in the course of these submissions, and this is scrolling down to page 21, is that we received information rather dramatically that it looked from inspecting the Dubai land register that the Villa K3 may have been sold. So all of a sudden, in the middle of the hearing, we're having to deal with that unheralded development and to seek appropriate interim relief, to adapt the existing interim relief that we were seeking to deal with that. There's a discussion about that with the judge, and I seek an adjournment for some instructions, and then we come back to it later. As to the judge says, as you'll see at page 24 at the top, well, obviously you'd need to think further quite what relief you might be wanting to seek. That is what happens there. There's then the second argument, which is about compliance, and I make submissions about that from page 24. And you'll see there's reference in line 19 to paragraph 4.3 of Schedule D, which is all about the paragraph dealing with the permissible uses of proceeds and the necessary and reasonable costs of operating and or maintaining the assets. At page 26 then, as I'm finishing up those submissions, what I'm doing actually is dealing with the email that we looked at, that 31st of October email that I took your Excellency to. But what I say at page 26, at line 22, is what the email does, and the problem with its non-exhaustive language and so on. And then at line 14, the second respondent's position seems to be that all she needs to do is say she's complying with the order, and that's enough. But that doesn't provide any comfort to us that the monies won't simply be dissipated. So that was the submission that I was making. And then after that, I go to the third defence, which is the offer to provide further information. And that isn't a matter that is being pursued for the purposes of the Fulham Frank breach. So I don't need to trouble you with it. But we then move on at page 32 to some discussion around the jurisdictional basis for seeking the interim relief. And I'd set that out in my skeleton. Justice Cook didn't need me to develop that in any detail. As you'll see in page 32, he says, we don't need to go there, do we? We've got a Court of Appeal freezing order, and the question is whether events have happened which suggest that ought to be varied in some way, at least on a temporary basis, until we can hear the full variation application. All that you said about risk of dissipation appears to be reinforced by the information you appear to have received this morning. And that's a reference to the information about the sale, or the apparent sale of Villa K3. And then there's a brief discussion about prejudice and the fact that if we block the sale, which is in train, there might be some aborted fees incurred by Mrs. Gupta and matters that could be covered under the undertaking. And then we deal then we come back to deal with the relief, the adapted form of relief necessary to deal with the fact that the sale appears to have occurred. And that's a discussion that happens on page 40 of the transcript. So that is the basic shape of what happened before Justice Cook. And he then went away that very day to prepare a judgment, a written judgment that he circulated that evening, rather impressively, dealing with the various legal points arising in respect of the stay, but also dealing with the important argument that was being raised about compliance and the second defendant's position that she had complied. Your Excellency will have seen the judgment, but effectively he totally rejected that argument by reference to the various submissions I'd made and the failures that had been identified, and held that she hadn't provided a reasonable summary of the dealing with the asset in accordance with the order, and that her apparent stated willingness to provide further information was no more than a stalling tactic. And then at paragraph 16, he said, "I have no hesitation whatsoever in granting the claimants the order as a result of the information obtained during the course of the 5th of November hearing. The restriction on disposals is obviously required." So that is what happened. That was the order that was made. Those were the reasons that were given. That's the factual background to what happened. I just very briefly, on the principles, this is the third part of my submission. I don't need to say very much about this. My learned friend obviously cites the Tugashev decision. It's well known. He relies on the bits he wants to rely upon. Your Excellency will be well aware that you need to take all those principles in the round and look at them. And importantly, you can't owe a duty in respect of a point that you can't have known about or reasonably foreseen. And equally, when you're looking at materiality, there are degrees of relevance and a due sense of proportion must be kept. And we do say questions of materiality are especially relevant in this case, where so many points are made about ancient history. Moving on to the substance of the complaint, which I know Your Excellency will want to hear about. There are, as you'll have seen, three breaches, three categories of breach in respect of full and frank disclosure. The first is the breach relating to the failure to advert to the requirement to show a Shabra basis for the relief sought. The second is various breaches of the DIFC freezing order, which it is said were not fairly presented to the court. And thirdly, there's a breach that is alleged in respect of the additional relief that was sought, which is said involved obtaining an impossible order, which caused, knowingly, we obtained that order, knowing that it would cause Mrs. Gupta, knowing that it was impossible to perform by Mrs. Gupta, and that it would cause her prejudice. And we say there's nothing in any of those complaints. And if your Excellency has the annex to the skeleton, it might be helpful to have that alongside as I develop my submissions on these points. The no Shabra basis, I don't need to spend long on this. You've heard from my learned friend, Mr. Peters. This would only be a good point if, in fact, we had to establish a Shabra basis, which we don't. And also if it was a point that had been adverted to by the second defendant in the period prior to the making of the interim relief application, and it was not. And that is a complete answer to that submission. And so I don't need to trouble you with the various detailed submissions that are made both in evidence and submissions by Mr. Trotter in relation to how the matter was presented historically as to how the matter developed, because they amount to an empty complaint. So I can move then to the second category of breach, which is the breaches of the DIFC freezing order.
Sorry, can I just interrupt for a second? Is it right to say that the matters of which all or some of the matters of which complaint is made reflected in your written submissions, your skeleton before Sir Jeremy?
Are we dealing now with the first or second category of breach? It's right to say I didn't raise the Shabra point, of course, in my submissions.
I understand. Yeah. So, I mean, they knew what you were saying because you'd filed a skeleton, and they filed their own skeleton. They didn't turn up.
Yes, I mean the skeletons were exchanged. As I recall, their skeleton was served late, but not long after our skeleton, so it wasn't directly responsive.
But it was before the court.
It was before the court.
Yeah.
And that was why I summarised the matter in the way I did when I said there were 3 points, which did not include Shabra.
It's a rather unusual situation to have a complaint of failure to make full and frank disclosure when a party is on notice of the other side's arguments, has filed submissions before the court, and doesn't appear on the day. Anyway.
Yes, I mean, indeed. And of course, what my learned friend does is he cites the authority on the duty existing in a short notice context where there is dicta.
This isn't a short
notice. Which is a
context.
different context. So that's the Shabra point. The second category of breach is that it is said that we mischaracterized and unfairly represented the alleged breaches of the DIFC freezing order by not explaining how that order should be construed. It's not actually said what we should have said as to how it should be construed, but the submission seems to be that whatever Mrs. Gupta did was obviously compliant or arguably compliant, and we should have made that point. That seems to be the headline point. We say there's nothing in that at all. It was obviously not compliant. And therefore, there wasn't any obligation to suggest on our part otherwise. We did take Justice Cook to the relevant provisions. He had them well in mind, as his judgment makes clear. And he also had well in mind the nature of the notifications, purported notifications that were made. So he was able fairly to draw conclusions as to whether there'd been a breach or not. And he clearly concluded there had been. That is the headline point. But in terms of the specific criticisms, there are, I think, seven criticisms, and you'll see them in the sub lettering under breach 2 of Annex 2. So let me just briefly address those and what we say about them. The first is that they complain that it was inaccurate for us to say that the asset disclosure in 2023 in England and in 2025 in the DIFC was materially the same. Now, we don't accept that, or we don't accept in the first instance that has any relevance at all, but because that was not a matter that was material to the relief that was being granted. But in any event, the point we were making, the material point we were making, was that the DIFC asset disclosure was inadequate. And the reason we said that was because Mrs. Gupta, in that asset disclosure, claimed that Vision had ceased operations and had significant unpaid creditors' liabilities, but without providing any further information. And we addressed it in paragraphs 30 and 66.2 of our skeleton. And the only response from Mr. Fedrigoli is that there was no obligation to do that. Well, we say clearly there was, that they needed to furnish that bare assertion with some information. And in fact, it's only long after the event that we've had this explanation come forward as to the nature of what that liability was, but there was nothing in the asset disclosure. So that complaint goes nowhere. The second complaint is a complaint about the comment made around legal fees and litigation funding, and this is that the claimants said in Mr. Lakin's evidence that the 2025 asset disclosure was inaccurate because it stated that the second defendant had less than $65,000 in cash, and that wasn't credible given the volume and the size of the assets that are in play. And their response to that is, well, of course it was credible because and the reason we said it wasn't credible was because of the volume of the legal fees that must have been incurred in the context of the litigation, and so having cash holdings of that small amount was not credible. And they said, well, no, it was credible because because the legal fees were being funded, and so that explains that apparent discrepancy. But that is not a good point for two reasons. First, whatever funding arrangements were said to be in place, that's immaterial to the dissipation risk. At best, it was a background fact. And secondly, the funding agreements relating to the first defendant have only recently been disclosed. That's dealt with in paragraph 104 of Mr. Wilm's first statement. They were disclosed in the English proceedings, not the DIFC proceedings. They're extremely opaque. There is no obvious explanation for the second defendant's allegedly minimal cash holdings. And those funding agreements, of course, as we will come on to later, are not related to the second defendant. And thirdly, none of this information was available to Trafigura at the time of the 5th of November hearing about the funding. Nothing had been disclosed about funding at that point. There was nothing at all about it in the second defendant's asset disclosure. So it's really fanciful to suggest that we were under an obligation to disclose legal funding arrangements about which nothing had been disclosed and about which we knew nothing. The third category is a complaint that is made about what's called the first Villa K3 notice. And this is a notice that was purportedly given on the 1st of May 2025 by email. For your note, it's in section U, tab 3. It's an email of the 1st of May. It refers to the proposed sale of Villa K03. First point, same as before, materiality. This is over 6 months before the 5th of November hearing. It has no bearing on the material risk of imminent dissipation around the time of that hearing. The second point is there's nothing inaccurate in what was said in Lakin 2. It's described as careful drafting. But the fact is that this was a purported notice under Schedule C, not Schedule D. So it's accurate to say that no Schedule D notice had been served. And the second defendant has never explained why no Schedule D notice was served. What she appears to say repeatedly is that notice on on solicitors representing a party in one set of proceedings in England is good notice in respect of a different set of solicitors operating from different offices in another set of proceedings, and that's not correct as a matter of law. She needed to give separate notices, and she didn't do that. The fourth complaint is 2D, which is that there's been the no disclosure, that our complaint that there's been no disclosure of the use of the proceeds is misdirected. And that point is developed by my learned friend by saying that there was simply no obligation to state in any detail the intended use of the proceeds. All that had to be done was to say, in effect, I'm complying with the order because I'm proposing to dispose of this asset in accordance with one or more of the prescribed purposes, without actually explaining what they were, what the specific intended use was. And we say that that is just not, if that really is the second defendant's position, that is not a tenable reading of Schedule D. And in particular, the combined effect of paragraphs 4 and paragraph 7.2. Paragraph 4 is the obligation to deal only in accordance with one of the prescribed purposes, for the proceeds to be used for one of the prescribed purposes. And paragraph 7.2 is the obligation to provide a reasonable summary, including what, if anything, the second defendant was to receive. And really, we make 2 points. The first is that the commercial purpose of these provisions, the commercial purpose of the freezing order was to allow Trafigura to police compliance with the order. Compliance requires the second defendant to provide an informative notice as to the use of the proceeds. Otherwise, that purpose would be frustrated. Without that detail, supplemented as necessary with documentation, Trafigura could not tell or know whether the proceeds were in fact being used as stated. That's the first point. The second point is the reasonable summary obligation in paragraph 7.2 is non-exhaustive. But it does extend explicitly to stating the commercial purpose, that's subpara B, and D, information as to the second defendant's receipt of the proceeds. And we say that that can only be construed as meaning that she was under an obligation to summarize in reasonable detail how the proceeds were to be used and how such use fell within the prescribed purposes. And the alternative construction, which appears to be the second defendant's position, is simply that she could just pay lip service to the order and say, I'm going to use the monies for any of the prescribed purposes, and that's that. And if that were truly the position, then frankly it would be a fraudster's charter, this type of order, and it would have no bite at all. And that's just a totally unrealistic position for the second defendant to adopt. But it is necessarily the position she has to adopt for her argument to work. The fifth point is various other alleged failures in respect of a failure to provide information about buyer identity, form F, valuation. What we say about this is that in the context of an entirely uninformative notice, these complaints are irrelevant. But in any event, a reasonable summary would certainly include identifying the buyer, because we'd want to know, for example, was it an arm's length transaction? It would certainly include providing a copy of the Form F, if available. And it would include providing some valuation information, because otherwise, how can we verify what's being asserted as to the reasonable market value? And it really goes to the same point. How can we police the order if we don't have this basic information? And as your Excellency will be aware, what's striking is that the Form F was entered on the 28th of October, naming the buyers, but that in neither the information as to the buyers nor the Form F was disclosed. Really, that's another bad point. The next complaint is 2F, which is a complaint about what's called the Platinum Tower notice. That was a notice that was given purportedly on the 27th of August in respect of a different property. Again, same point about materiality. It predates the 21st of October variation application. It's not material to the risk adverted to. But in any view, on any view, it was not.
Sorry, the complaint, this matter and the matter before looking at the third column of Mr. Trotter's very helpful table, seems to be that you presented a particular interpretation of the order, which, when as though it were set in concrete, when in fact the order was contestable. But no doubt he'll say something about that, but I've got difficulty with that. You're presenting it to a judge who can read the order and can look at it for himself. I'm just not sure how much you need to say about this class of complaint.
No, well, Your Excellency is right. I mean, of course, these are granular matters. I mean, the headline submission I was making before Justice Cook was the total absence of meaningful information in the notices, leaving aside precisely what was required to be notified, whether specifically there was an obligation to provide a valuation report, for example. But that doesn't go anywhere. When one looks at the notices, they had to provide meaningful information, and there was nothing of the sort. And what is more, there was, as I say, there was these sort of weasel words where the way in which it was expressed, including but not limited to, in this non-exhaustive language, effectively appeared to be directed to providing some superficial compliance on the face of it, but actually reserving the position to do something which the order didn't allow. So it was totally inadequate, and as Your Excellency says, Justice Cook could readily see that when shown the orders and when shown the notices alongside the Schedule D provisions. So that's the Platinum Tower notice, and just on that notice, that second notice, that in fact is I mean, it was non-compliant anyway, because that was the notice that referred to the use being the settlement of the old trade debt of Vision, but again, no details, and it's only after the event that we've got those details, and it was it included that non-exhaustive language as well. So that's the Platinum Tower notice, and then final complaint is relating to the second Villa K3 notice. Now that is the Larson letter.
That's the same class of complaint, isn't it?
It is exactly. I mean, you've obviously heard what my learned friend Mr. Peters said about it in terms of why it didn't comply, and indeed why it contained false statements, which we didn't know were false at the time, but clearly is a material factor now for Your Excellency to bear in mind. But it is essentially the same complaint. We accept that this notice and how we presented it to the court was material. It's distinct in that respect because it post-dated the variation application.
Well, the second defendant says in the third column in 2G, this is the same pattern as above. Each quote, breach, unquote, depends on the claimant's own expansive reading of the order. So it's a complaint based on your presentation of a particular reading of the order. And again, I don't know that I'll be interested to hear any elaboration from Mr. Trotter on that, but I've had difficulty fitting that into a full and frank disclosure framework. I mean, if somebody says to a judge, this is the only possible construction of this, or this is the only reasonable construction of this or that provision of a statute, and then somebody else comes, and it's in the context of an ex parte application, and somebody else comes along later and says, well, there is another reasonable construction. It doesn't mean that the person who said there's only one possible construction or only one reasonable construction has been misleading the court. They're an advocate. Obviously, there are questions which the court could not be expected to, as it were, be able to answer on the face of the materials before it, and would require that duty of disclosure to be engaged. Some underlying fact which doesn't emerge and should be, of which the court should be informed, for example.
Well, indeed, and of course, it wasn't the position I mean, it certainly was. It was the position before the hearing that they were saying, well, we don't need to comply. We simply have no obligation to comply. And indeed, that was a fact that sat uncomfortably for Justice Cook with the way in which you interpret their conduct, because they were not saying, well, our obligations are X, Y, Z, and the way that you interpret these is as follows. And this is why we've only done what we've done. They were simply saying no obligation to comply, and here you go, and that's compliance, but not explaining why it was compliance, and it obviously wasn't in our submission. And so there wasn't any there wasn't any full and frank obligation in that regard. But importantly, Mr. Trotter hasn't actually developed why what he says the obligation was, why he says it was so limited. We've never actually had that case. All he said is what we did was enough. So it's never been developed. And again, that's another reason why it's just not a tenable basis for a full and frank complaint. So we say that Justice Cook had all the material and drew the right conclusions on those points. And that brings me to the third category of breach, which is the impossible order argument. And that really breaks down into two complaints, as you'll see from the table. The first is that the order we sought, which is the order addressing what was to be done about the fact this villa had been apparently sold, that order that we sought was an impossible order. And the second point is that there was prejudice arising out of that order. But that first submission is really quite a remarkable submission. I've shown you that what happened at the hearing, that we had to adapt the interim relief on the hoof because we discovered that the second defendant had secretly sold the villa, or so it appeared. We had no insight into the structure of the sale, and it was perfectly reasonable to seek an order requiring the vendor and the registered legal owner to pay the proceeds into court to avoid dissipation. And indeed, we know now, although we didn't at the time, in accordance with the terms and conditions, that she was the party to whom the proceeds were to be paid, although she now disavows that explanation, but that's what the Form F says. We also know, because it said so, she said so in her own email on the 31st of October, that she would receive the proceeds. So the idea that we were somehow on notice that it would be an impossible order is totally unsustainable. And despite this, and I should just go to this actually, because we do say that this really does push matters above and beyond. It's 7.3 of my learned friend's skeleton argument, where he says, having obtained an impossible order requiring Mrs. Gupta to pay money into court that the claimants knew she did not have. I mean, that appears to be an allegation of deliberate misconduct, seeking an order knowing that it was impossible to comply with, and that there is absolutely no justification for that allegation, and it should never have been made. But the third point is that it wasn't an impossible order, because if you look at the order, and this is section D, tab 8. Sorry, it's tab 9. And you'll see that the paragraph 4 is dealing with the provision of information around the sale. And then paragraph 5, this is the relevant provision. You see the first sentence, there's an obligation or a restriction precluding the second respondent from not disposing of, dealing with, etc., the proceeds. And then it's the second sentence, which is said to be objectionable. Within 24 hours of service of this order, second respondent must transfer or procure the transfer of the proceeds from any bank account in the name of the respondents or under their control. So what that is doing perfectly sensibly is saying that if she holds the proceeds in a bank account in her name or her husband's name, or in the name of a company that's under her control, then she has to transfer those proceeds to court. If she doesn't, then she wouldn't, because it wouldn't apply. So it's not an impossible order at all. Now, and the last point on this is prejudice, and this is a follow-on point. I mean, obviously, if it's not an impossible order, then the point about prejudice goes nowhere. The short point is that any prejudice, in inverted commas, that she suffered was caused by her own conduct, because she elected not to pay the proceeds into court if she received them, and she elected not to provide information in relation to the sale. And those choices were made in the face of an order of a freezing order of this court, but also in the face of orders of the onshore courts. And that was why she faced an arrest warrant. That was the logical consequence of non-compliance. So there's that point. But then the other point that's made is that it was a misrepresentation for me to say that the order I was seeking from Justice Cook was to hold the ring. But that's not correct, because the order I was seeking was to hold the ring pending determination of the variation application. And it's well understood that the only way the ring would be effectively held would be to seek execution on shore by way of precautionary attachments, because otherwise, how would you effectively block the sale of the assets? And it would always have been opened for the second defendant to flout the order. So we don't accept that was a mischaracterization at all. It's a logical consequence of the relief we were seeking. Very briefly, there's a point made about the failure to provide a note. We've been upfront about this. That was an administrative error caused by a miscommunication between the previous solicitors, Stevenson, Harwood, Dubai, and Opus, who were recording the hearing. And we've apologized for it. But the important point is it didn't cause any prejudice to Mrs. Gupta. She was served with the Cook order. She was served with the reasons. She had every opportunity to, based on those reasons, based on that order, to understand what had happened. And she could have asked for a copy of the transcript. Of course, we accept we were under a duty to provide it. But she had all the information available to her that would have allowed her to progress this application earlier. And so she hasn't suffered any prejudice as a result. What she did was she buried her head in the sand and chose not to. Finally, I should briefly address Your Lordship, Your Excellency, on appropriate relief. Of course, we say we don't get there in terms of the appropriate relief for the alleged breaches of full and frank disclosure, because there are no breaches. But I should say that in that hypothetical scenario, there is ample material. All the submissions made to Your Excellency this morning by Mr. Peters amply justify the grant of the relief we're seeking. Whether or not there had been some breach, but of course we totally refute that there has been. And we totally refute, I should say, and put it on the record, because what's now alleged, what wasn't alleged previously, but what's now alleged, is that the failures of full and frank disclosure were deliberate. That's obviously a very serious allegation. and it's an allegation which I think is being made. Well, it may encompass legal counsel or not, but whatever the position, it's a serious allegation. There's not a shred of evidence to support it. The presentation of the application was full and fair. And on the other side of the equation, you've got the second defendant's conduct, which has been reprehensible in secretly selling the villa, deliberately choosing not to attend the 5th of November hearing, and then flouting the cook order and the enforcement orders. And she's demonstrated a complete disregard and disrespect for the orders of this court, and shown a real and present risk of future dissipation of the assets subject to restraint. So for all those reasons, we would say that that justifies maintaining the relief and continuing the relief granted by the cook order.
Thank you, Mr. McPherson. Yes, Mr. Trotter.
Sorry, Your Excellency, I was going to say...
You have something more to say.
Well, there's the funding disclosure application, which I can deal with now, but it is perhaps off to one side. So if you would prefer to go straight into hearing from Mr. Trotter, I can pick up the funding disclosure application separately at the end.
We might as well deal with that now, so Mr. Trotter can respond fully.
Very well. I won't be long. So this is the application that is dealt with towards the end of our skeleton. It's paragraph, sorry, if you just give me 1 second, it's paragraph 79 and following of our skeleton. And we seek the orders specified at paragraph 87, namely an order requiring Mrs. Gupta to produce a copy of the agreement under which her legal fees for these proceedings are being funded, and to serve an affidavit specifying the amount spent, the date when the funder NOMAS commenced funding, and provide full particulars of payments. Now, we say we're entitled to that for a number of reasons. First and most obviously, Mrs. Gupta appears to be spending a great deal of money on these proceedings in circumstances where she claims effectively not to have 2 pennies to rub together on her own account. And we say, therefore, that understanding her funding properly is an important part of policing the DIFC Chabra order. We need to know where she is getting money from. Now, the suggestion is that this entity NOMAS is funding her, but no details of the terms, amounts, how the funding has been provided have been given. So we are completely in the dark. Yet again, what has happened is that very high level, very general information has been provided that is not really useful to policing the orders we've obtained. Now, the need for the information is particularly acute when one considers the position of NOMAS itself. As I mentioned earlier, it is not a professional funder. It is not an entity like Burford Capital or anything like that. It is said to be owned by His Highness Sheikh Mohammed bin Sultan bin Hamad Al Nahyan, a member of the Abu Dhabi royal family, and is said to be funding both Mr. and Mrs. Gupta's legal fees in relation to these and the English proceedings. And in relation to Mr. Gupta, that funding is said to have continued post-judgment. We say it is very hard to understand what possible commercial interest a company owned by a member of the UAE royal family could have in the Abu Dhabi royal family could have in funding the defendants in these circumstances. First of all, funding Mr. Gupta after he has been held liable for $700 million plus in respect of a massive fraud in circumstances where there is no obvious or indeed identifiable upside to such funding, and funding the second defendant again in circumstances where there is no upside to that funding or no ascertainable upside to that funding, and she claims to have little or nothing in the way of assets of her own. On the face of it, providing litigation funding in those circumstances makes absolutely no sense at all. And it raises a question as to whether something else is going on here. Now, our concerns on that front are exacerbated by the point I took you to at the end of my opening submissions, concerning NOMAS itself, which is, I showed you that Form 6K, suggesting that NOMAS is participating in what one broadly call investment business in the UAE, nothing to do with litigation funding. And in the course of that business, it is dealing with Al Noor, the entity that received the proceeds of the dissipation of Villa K3. So we do say, to put it colloquially, that without further explanation, the funding position stinks to high heaven, and that given the history and given the limited information we have, it is entirely reasonable that we be provided with proper disclosure of what is going on in relation to Mrs. Gupta's funding, where that funding is coming from, and who it is going to. And Your Excellency, that I've kept it reasonably short because it is a relatively simple application, and I don't criticise him for this, but it wasn't dealt with expressly in Mr. Trotter's submissions, so I will see what he says about it orally and then deal with it in my reply if I need to.
All right, thank you very much. Yes, Mr. Trotter.
Thank you, Your Excellency. I propose to deal first with the abuse and chabra points, which are overarching and affect both applications, then to deal with my discharge application, then thirdly to deal with Trafigura's variation application as it's been termed, and then finally I'll come on to the legal expenditure application, which wasn't dealt with in my skeleton argument, as my learned friend says, but that's because we had anticipated that it had gone. Now, turning to the abuse and chabra point, the thrust of my learned friend's submissions is, of course, that he doesn't need to establish that the assets in relation to which he now seeks relief are amenable to execution, because that has already been established long ago before Your Excellency in the Court of Appeal, or at some time prior to that. And Your Excellency will have seen we have two objections to this. First, it's abusive. Second, it's wrong. We say it's abusive because Trafigura has already tried to convince the Chief Justice of this point in February 2026 and didn't get traction. The point was ultimately conceded first orally and then in writing, and the hearing was adjourned on that basis. Since then, a great deal of ink has been spilled and costs incurred on the substance of the question, so we were quite surprised to see the point come back after Trafigura changed solicitors. Now, there doesn't appear to be anything between us on the law. Both parties rely on the same authorities. There are three familiar points which perhaps need no authority. First, that the principles of abusive process apply as much to interlocutory applications as they do to final hearings. That's in COSA and COSA Alton in the authorities bundle at 35/913 G to H. Second, the fact that a party has capitulated at the first encounter cannot improve that party's position on the second. Those are the words of Lord Justice Buckley in Chanel and Woolworth at authorities bundle 8/248A. And third, in the end, the question is whether the point could and should have been pressed on the first occasion, or as it's put colloquially in many of the cases, whether one party is simply trying to have another bite at the cherry. Now, there was an additional proposition put by my learned friend orally. It was suggested that concessions made by counsel during a hearing in exchange with a judge do not usually bind. Now, I confess that sounds like quite a nice principle if it existed, but it wasn't supported by any authority because, sadly for all of us, there is none to that effect. Now, Your Excellency will have seen the parts of the transcript in my skeleton argument, and Your Excellency was taken to them again during submissions this morning. So I don't need to go over all of it in detail, but I should just take Your Excellency back to the critical parts because Your Excellency was shown some, but not all of it. The transcripts at tab C11 of the bundle or at page 845. I think Your Excellency may have been sent a PDF version, or at least a link to download one.
I have, but I've got the version I have here shows the alphabetical tab number and then the class of the document tab number. So that's working if you give me those references.
Yes, okay.
I noticed incidentally that Mr. Peters is not on screen anymore, but I presume he's present.
I'm sure
Yes,
he's
I
being
am. If the
attentive.
court would prefer me to keep my camera on, I'm more than content to do so.
As long as you're there, Mr. It's the equivalent of turning your back on the court, I suppose, which used to be a grave offence in my day when I was counsel. Okay, whatever's comfortable for you. Go on, Mr. Trotter.
So, Your Excellency, I'm at page 845 in the bundle, which is the first substantive page of the transcript. And we see Mr. McPherson starts by explaining his submissions are going to be in 8 parts, the 5th of which is the Chabra point about halfway down page 3 of the transcript. If we go down to page 4, line 4 onwards, the Chief Justice picks up on this point straight away and says that it's rather central to everything because otherwise everything else falls away. And then at the bottom of page 4, Mr. McPherson starts his argument on that point, explains that they say it's already been established because the whole basis on which, firstly, the undertakings were given in the English proceedings and then the order was made in the DIFC was that the Chabra jurisdiction existed. And the Chief Justice then says, well, sorry, the order in England was noting undertakings, and then explains His Excellency's view of what happened when things came to the DIFC. Now, there then follows a few pages of...
The order in the UK noted the undertaking. It didn't accept it. Is that right?
I think what His Excellency means there is notification undertakings. The
Oh,
order in England is notification undertakings. Yes.
Yeah, but the order, the undertaking in the UK, in England, had injunctive effect, a formal undertaking to the court accepted by the court. I think
Well,
Mr. Peters is nodding affirmatively.
Yes, well, it was a consent order entered into between the parties that contained in the Schedule C the undertakings that Your Excellency has been shown.
Yeah, well, there's a long line of authority, certainly in Australia, that a court would not accept an enforceable undertaking that it couldn't, that would be beyond its power to frame as an injunction.
Well,
they consider the parties. Yeah,
that's no doubt right. I mean,
it's framed as an undertaking given to the court in Schedule C itself. So it is a consent order. My learned friend is right. It's also a promise to the court. And if you breach such promises, the court will be unhappy with you.
Well, it's like an injunction from the court.
Yeah.
Yes, and I'll come on to in a moment how things developed in England and the DIFC. At the moment, I'm just dealing with how things unfolded in February of this year.
Yes.
Before the Chief Justice, where this point was pressed but ultimately not maintained. Now, if we go over the page to page 847 of the bundle.
Yeah.
We see there's some argument over pages 10 and 11 about the effect of the orders that were made and whether, in particular, the question whether the properties are subject to the Chabra jurisdiction has been separately determined or not. And then we see at page 11, lines 12 and 13, Mr. McPherson accepts that it hasn't been separately determined. He says because it hasn't needed to be. The Chief Justice asks, well, you say hasn't been separately determined. What do you mean by that? Either it has been determined or it hasn't. Response, no, it hasn't. Now, it was said this morning that this was just confined to a statement about the English proceedings because he goes on to explain that the Chabra determination took place before Judge Pelling. Further assets were captured, as I've explained, were subject to the undertakings. But it's not suggested anywhere here that the point has been determined anywhere, whether in England or in the DIFC. Now, in light of that position that's been taken, the submissions then move on to a different topic. And over the next few pages, the second submission is that the court has the power to make its existing order effective. So it's no longer being argued that the Chabra jurisdiction has already been established. Instead, there's a different basis for the relief that's being put. And we see the Chief Justice's reaction to that at page 12, line 13, where His Excellency says, well, how does that help? I should only exercise the power if there were grounds to believe that the assets, the subject of Schedule D, would be available for execution. Now that carries on over a few more pages. There are various submissions made about substantial control, in which Trafigura is now inviting the Chief Justice to make the finding on the evidence that was before the court at that time. And we see where we ultimately end up at page 17 of the transcript, which is 849 of the bundle. We're starting at page 17, line 18. And the Chief Justice is here discussing the submission that because Mrs. Gupta disposed of Villa K3, it therefore follows that it was an asset belonging to Mr. Gupta. And the Chief Justice expresses some skepticism about that argument. And ultimately, on page 19, line 18, the Chief Justice asks, well, are you asking me to make that finding now? And the answer is, yes, I am. But then Mr. McPherson can rightly feel which way the wind is blowing. A couple of lines down says, I can see Your Excellency is reluctant to make that finding. And ultimately, what happens then is that the lifeline that's thrown to Trafigura to put on more evidence about that point of substance is accepted, and the hearing is adjourned. Now we see where we finally end up over at page 852 of the bundle. It's page 32 of the transcript. And the Chief Justice from line 13 onwards is explaining what will need to happen on the next occasion, which is this hearing. And His Excellency's view is that it's necessary to maintain the orders in order to protect the remaining properties until we can ascertain whether they do in fact fall within the scope of the Chabra jurisdiction. If not, that's probably an end to the matter. If they do fall within the Chabra jurisdiction, the next question would be whether the court order should be discharged. So the point about all of this is that the purpose of the adjournment was to put on more evidence about the question of substance, about whether there is reason to believe that there could ultimately be execution against these properties. It was, of course, not necessary for the adjournment in order to delve in more detail to the procedural history and make the arguments which Your Excellency has heard today. Those arguments could have been made and should have been made, if they were going to be made, at the hearing in February. But the reason they weren't made was because it was ultimately conceded. And we see that that's how Trafigura's legal team saw matters at the time as well, because in Mr. Lakin's 8th witness statement, which comes only a few weeks after that hearing, it's expressly accepted that there was no finding in England as to whether the Chabra jurisdiction requirements had been established. We see that at C14, page 891. There's quite a lengthy discussion in this witness statement of the procedural history. And where we end up on page 891 at paragraph 48 is Mr. Lakin concluding the English court has never addressed the question of whether there was or is reason to suppose that the Schedule D assets were or are held by R2 Mrs. Gupta on behalf of R1 Mr. Gupta. And Your Excellency, it is striking that this point does not get rebirth until Trafigura changes legal team. Now, obviously, the new legal team have just taken a different view and considered that this point was worth pursuing, but it was firmly abandoned at the February hearing and then again in writing. If it was going to be made, it should have been made then. Now, there was another point.
Can I just understand? I'm not trying to understand my learned friend's point. Is the point that we're not allowed to argue to do with the determination of the matter in England, which is what Mr. Lakin is expressly referring to? Is that the point on which there is an abusive process?
Well, Your Excellency, Mr. Peters will have his opportunity to reply. I did not interrupt his submissions.
Yeah, let's get on with it.
No.
Mr. Peters, save it for reply.
No. If necessary, in Mr. Lakin's statement while we're here, it equally accepts, if we go back to page 881, sorry, 882, over at paragraph 7, Mr. Lakin is explaining, I'm aware that for Trafigura to obtain travel relief, it must demonstrate to the court that assets R2 holds in her name or through vision may be amenable to some process of execution, ultimately enforceable by the courts to satisfy the judgment. And that's setting up the entire purpose of this very lengthy witness statement and the expert evidence that is served with it. But what one does not see anywhere in this witness statement is some contention that actually that point had already been established either in England or before Your Excellencies in the Court of Appeal in the DIFC. And the reason that's not asserted is because that point has at this stage gone. And it's not until Mr. Williams serves his first witness statement that we see it come back. Now, my learned friend, Mr. Peters, took Your Excellency to the Chief Justice's reasons in granting the adjournment, and Your Excellency was right to observe that the Chief Justice was not inclined to resolve this question as a preliminary issue or to reserve it to himself. But none of that really changes the landscape that we've seen at all. And in fact, to the contrary, if we look in Mr. Williams' third witness statement, we can see what Trafigura was saying about this at that stage. That's at F4, page 1585. And at paragraph 15, Mr. Willen takes the position that whoever hears the applications will doubtless be referred to the transcript, as Your Excellency now has been, and will be perfectly well placed to address A, the meaning and effect of the Court of Appeal's orders, and B, whether arguments on that point are open to Trafigura. Now, it was suggested that somehow the Chief Justice had resolved this point against us and decided that it was still open to Trafigura to contend that the Chabra jurisdiction had already been established. But that wasn't even Trafigura's own position in Mr. Lakin's witness statement, and nothing in the Chief Justice's order could be taken as having resolved that point. So that's all I propose to say about abuse. Now, if Your Excellency is against me on that, and it does remain open to my learned friend to contend that the Chabra requirements were proved either in England or in the Court of Appeal, then we say that is wrong. That is not what the judge found in England when His Honour Judge Pelling made findings about Silver Star and Villa K1. Since then, no judge has been invited to make findings about the amenability to execution of any other asset, and much less have such findings been made. Can I start with the judgment of His Honour Judge Pelling? Your Excellency, again, was taken to some parts of this, but not the key parts. If we could bring up J5/1766. And if we go over to page 1769, and it's paragraph 6, which is really the key paragraph. And the judge has regard to the evidence that's been submitted by Trafigura. And 3 lines down, we see His Honour explains, I should add at this stage that the primary submission made by the claimant is that should be a maximum sum order made against Mrs. Gupta on the basis of an inference apparently that because there is a realistically arguable case that 2 assets identified by the claimant satisfied the Chabra test, it therefore follows that I should infer that all assets held by her are to be treated as having satisfied that test. I regard that as extravagant. All the more so because Mrs. Gupta is not domiciled in England, but in any event, the evidence available does not justify the inference of such a wide-ranging conclusion. Now, it was suggested earlier by my learned friend that the only reason that His Honour Judge Pelling didn't make orders in relation to other assets was because he wasn't aware of other assets. But the reasoning is not as confined as was suggested. The indication is that it's extravagant, simply to assume that all other assets are equally subject to the Chabra jurisdiction. And that's illustrated by the fact that the judge declines to grant an order in respect of the funds in Mishcon de Rey's client account because they are of a lesser value, and the same inference can't be drawn in relation to those funds. Now, the order that was given ex parte is at J4-1757. We probably don't need to turn it up, but Your Excellency will see at page 1758 that it applies to Villa K1 any interest in Silver Star and any interest in any company through which that interest is held. And my learned friend rightly points out that it requires Mrs. Gupta to give disclosure of assets worldwide, the point being that once Trafigura was aware of other assets, then they would be entitled to come back and apply for relief in relation to them. Mrs. Gupta duly gave that asset disclosure. That disclosure, the reference is M162567. Don't think we need to turn it up, but it discloses Villa K1, sorry, Villa K3, as well as Villa K1, K3 being a much less extravagant property worth a significant amount less. And it also notes that Vision owns various properties that were acquired for about $1.8 million US. Again, nothing of the order of magnitude of the Silver Star shares that His Honour Judge Pelling was willing to make findings about. Now, it was at that stage perfectly open to Trafigura to apply for Chabra relief in respect of those properties if they were so advised. My learned friend said in his submissions that if Trafigura had applied for chabba relief, then there is no doubt that it would have obtained it. But the point is, Trafigura did not apply for that relief. Instead, the parties agreed a holding regime, which came to be known as the Schedule C regime in England, and that later culminated in a letter to the court on the 1st of June 2023, which is at K22119.
Yes.
And it simply states that the parties have agreed to vary the terms, and a signed consent order and confidential Schedule C is enclosed. Now, if Trafigura had made an application for chabba relief in respect of these various properties, it would have been contested. We know that because Mrs. Gupta said so in correspondence at the time. But the order, the regime that was agreed in the end is that was embodied in the consent order entered into between the parties. That order is at J91795. If we go over to page 2, internal page 2, bundle page 1796, the injunction now applies to Villa K1 and the shares in Vision. So it's been modified so that it attaches to the property that is owned by Mr. Gupta, not the property that is owned by Vision. And over the page at paragraph 6, the order now contains the usual exception for the ordinary and proper course of business. And then Schedule C to that order is at a different tab, unfortunately. It's at 8046 of the bundle, which is tab U5. And we see it provides undertakings given to the court. It says this order does not apply to the following assets, and it lists out Villa K3 and the 15 Vision properties. It then contains various terms on which Mrs. Gupta had undertaken to deal with those properties. First, that they have to be at market value. Paragraph 2, that the proceeds are to be used for particular purposes. And I pause to note here, because it's relevant later, that this is an obligation as to how the proceeds are to be used, rather than a disclosure obligation to explain and give chapter and verse about how they are to be used. Over the page at paragraph 3, one of those uses is to make loans to Mr. Gupta in respect of his legal fees. And Your Excellency will note that Trafigura required that those monies be paid directly from the second defendant to her solicitor's client account to be held there for that purpose and not paid via the first defendant. I flagged that because it's similar to a provision insisted upon by a different creditor, Sharp Trend, which we'll come to. And paragraph 5 is the notice requirement. And this is what we saw, similar to what we saw in paragraph 6 of the order itself. Before doing so, the respondent must provide certain details, the 72 hours notice, and then a reasonable summary of the proposed dealing, the identity of the assets, the purpose, its estimated value, and what they are to receive. Now, what's clear from that history in my submission is that the order was agreed in order to allow Trafigura the right to make its Chabra application in respect of those assets, if so advised. It threatened to make it, it didn't make it, and instead this holding regime was agreed. But what did not happen at any stage is a judge making a finding on which Trafigura can now rely that assets other than Silver Star and Villa K1 were amenable to the Chabra jurisdiction. Now, the next stage is the DIFC proceedings. Your Excellency will be more familiar with these. If we could pick it up with Trafigura's skeleton argument at the first without notice hearing. That's at tab A5, page 48. We go over to page 57. There is, starting at B4, an account of the English Chabra order, as it's called. And then over the page at 41, there's a summary of what His Honour Judge Pelling held. And the court's being told that the judge held that there is good reason to suppose that Mrs. Gupta is holding relevant assets, being the villa and the shares. That's a reference to Silver Star. At 42, we see the limited basis on which the relief was granted. And then at the bottom of the page, 45, Mrs. Gupta gave her disclosure. The disclosure revealed that Mrs. Gupta had held substantial assets in Dubai, including those over the page for which His Honour Judge Pelling KC had concluded that there was reason to assume were held on Mr. Gupta's behalf. So there is an acknowledgement, at least at this stage, that it's only in respect of certain of those assets that a finding had been made that there was a reason to believe that they were held on Mr. Gupta's behalf. Then the substantive part of the skeleton is over at page 78, which is the application for Chabra relief. This is the part that my learned friend took you to. If we go over the page to paragraph 130.1, we see the court is told there are two assets, Villa K1 and the Vision shares, in respect of which there are good reasons to believe that are held by Mrs. Gupta on Mr. Gupta's behalf. And a few lines down, that was the basis for the English Chabra order, the Pelling judgment. That's slightly inaccurate because, of course, it was the Silver Star shares that were the basis for the Vision judgment, but I'm sure that's just a slip. If we go further down to the bottom of the page, separately, Trafigura seeks to replicate the terms of the undertakings agreed with Mrs. Gupta in the English proceedings in Schedule D to the order. And so what Trafigura is expressly proposing is purely to reflect the agreed regime under Schedule C in the order granted by the DIFC court. My learned friend skipped over this paragraph when he took you through the order, and he said, we weren't just saying you should do what was done in England, but that is precisely what Trafigura was saying. There is no attempt to convince the DIFC court that there is reason to believe that the additional assets would be amenable to enforcement as well. And we see the same thing over at page 83 when the draft order is being described. So there's a heading draft order, and then down below that G2 Schedule D assets. And 2 lines down, those provisions replicate the undertakings voluntarily provided by Mrs. Gupta in the English proceedings, and in that respect, do not impose any additional burden on her. Much the same thing, again, over at page 87, under the heading Full and Frank Disclosure. under need for relief, 157 to 158, the justification given is that there is need to give more teeth to the injunctions. So again, what's being said is that the same relief should be imposed in the DIFC, not for the purposes of upgrading it in any way, but just to give it more local effect. Now, the without notice application, as we've seen, was supported by Mr. Lakin's affidavit. That was to much the same effect. That is at tab A3. If we pick it up at page 26 of the bundle, in paragraph 100, is where Mr. Lakin is describing the nature of the English regime. And he says, for completeness, the Chabra order does not provide freezing relief over all of the assets in which Mrs. Gupta has an interest. The operative part of the order requiring Mrs. Gupta not to dispose of, diminish or deal with or diminish the value of her assets applies to K1 and Mrs. Gupta's shareholding in Vision. Explains that Schedule C omits certain assets, and at paragraph 101, Mrs. Gupta is free to deal with those subject to various undertakings. Over at page 33, and again, this is the passage that my learned friend took you to, he asserts that there is good reason to suppose that Mrs. Gupta holds assets at paragraph 131. But as we've seen, the basis for that in paragraph 132 is just the same evidence that was before His Honour Judge Pelling in the English proceedings, which he confirms. Now he says at paragraph 133 at the bottom of that page, the above arguments were made at the ex parte hearing of Trafigura's application. It recounts that Mrs. Gupta has maintained she's independently wealthy and indicated her intention to apply the Chabra order on the basis that there's no evidence that Mr. Gupta has any beneficial interest in her assets. No such application been made, and the Chabra order remains intact. But Your Excellency, it's not the point that Mrs. Gupta had not applied to discharge the Chabra order in relation to Villa K1. The point is that Trafigura did not apply for Chabra relief in respect of the additional properties. Now, nor was any wider relief than this sought at the hearing of the without notice application. We can see what the judge was told in the transcript, which is at A6 of the bundle. And if we start at page 101 of the bundle, page 44 of the transcript, now we're obviously 44 pages into the hearing by now, so many other points have been addressed in some detail. We see at 44, line 11, leading counsel explains that in addition to the freezing order, you will have seen Trafigura also obtained the order against Mr. Gupta. I'll try to move a bit faster because there's a lot to cover. She's not a defendant of the proceedings. There's reason to believe she's holding assets for Mr. Gupta. And so we say that the judgment we get in England could ultimately be enforced. At the bottom of that page, there's not a lot I need to show you in relation to that. Over onto the next page. But essentially what we say, and it appears at paragraph 12 and 13 of the judgment, is that he was satisfied that there was reason to believe that the two assets which had been identified belonged to Mr. Gupta, even though they were nominally owned by Mrs. Gupta. And then further down, line 16 onwards, Mr. Montague Smith recites from paragraphs of His Honour Judge Pelling's judgment, which we've seen. And critically, at lines 12 to 15, what the court is told is he refused to grant an order generally, and we don't seek that today. We just seek to match the order. So again, it's clear that the court is being told that they're not seeking to expand the relief in DIFC, just seeking to match the existing regime that's been put in place. We see the same thing over on the next page, page 47 of the transcript, line 10 onwards. Properties are in Dubai. Then what happens is those particular assets are excluded from the prohibition in the order, but made subject to certain terms, so she can deal with them, but only on the terms set out in the order. She can sell them, for example. She can only deal with the proceeds in accordance with the terms of the order, and we have sought to replicate those terms in the order that we're seeking against her in this jurisdiction. So again, the court is being told that the relief being sought in the DIFC is doing no more, no less, than converting the agreed regime in England into an order in the DIFC. And there's certainly not an invitation to make findings on which Trafigura can now rely that those assets are amenable to, may be amenable to enforcement. And this is reflected in His Excellency's reasons. The Deputy Chief Justice's judgment is at A7 of the bundle, starting at page 133. If we go over to page 137, at paragraph 13, His Excellency is explaining the two ways in which the application was put. And he explains, I'll first assume that the intention of the application is to bring a fresh claim seeking relief that mirrors the existing orders of the English court. And then second, I will address the application of the relevant new law articles that would have been engaged if the application had been intended to seek enforcement of the existing orders. And Your Excellency may remember that before the Deputy Chief Justice, the application was put in those two ways. Of course, it didn't matter in the Court of Appeal because Your Excellency has found that Article 15B gave sufficient jurisdiction. But the point for present purposes is that each of those routes does not involve the river rising above its source. And indeed, the second route is expressly engaged in enforcing the English regime. Now, there then followed an appeal on jurisdiction, as Your Excellency well knows. Of course, the question whether Mrs. Gupta held particular property on behalf of her husband was just not in issue on that appeal, so it wasn't explored. My learned friend, of course, didn't have the benefit of an order from the Deputy Chief Justice, so he can't say that anything arises in his favour out of that. And if necessary, we probably don't need to go through it, but it's clear from the ex parte reasons and from the September 2025 reasons that recount the same manner in which the application was put below, in that it either sought new relief mirroring the English orders, or that it sought to enforce them. But there was no exploration of whether particular properties were amenable to enforcement or not. So we say that the position is now, as it has always been, that the claimants have not satisfied any judge anywhere of an entitlement to Chabra relief in respect of anything other than Villa K1 and the interest in Silver Star. We've seen that that has at various times been Trafigura's own position. And against that background, I do say that the position in my learned friend's skeleton argument is quite stark, because we see what he says now at page 10, at paragraph 14.1. about Your Excellency's order in the Court of Appeal. And Your Excellency is told that the DIFC FO was an order that the Court of Appeal should not, and indeed could not have made, unless it was satisfied that there was a sufficiently arguable case that the DIFC FO assets were amenable to the Chabra jurisdiction. Your Excellency, in my submission, that's quite a breathtaking submission, because he says that Your Excellencies must be taken to have made a finding about amenability. Never mind that neither Your Excellencies nor the Deputy Chief Justice were actually addressed on that. Never mind that it's not in the submissions, the evidence, and certainly not in the judgments. It's tantamount to saying that even though all they told the judge below and Your Excellencies was what they were doing was mirroring the holding regime in England, in fact, they were improving on their position in this court. We say that's just not right, and it would be wrong at this stage to accept that they had already established that point either in England or in the Court of Appeal. Now, finally, on this point,
what was the status? This is a little discussion I had with Mr. Peters, I think. What was the status of the Chabra point at that stage? It was sufficiently arguable to support an ex parte injunction. I guess that must be implicit. I mean, we said that, the real point was we said jurisdiction was sufficiently arguable and the ex parte injunction should have granted. Didn't address, but I guess if you were looking at an ex parte injunction with a right to discharge, you would ask yourself the question, is there a basis for Chabra relief? Or am I just adding a layer that is unnecessary there, that the test for Chabra relief itself brings in the notion of arguability?
I think Your Excellency's analysis is right. I think primarily we say that the DIFC courts at any stage just weren't addressed on this question and did not make findings and can't be taken to have made findings about whether the additional assets were amenable to the Chabra jurisdiction or not. Because whatever the legal requirement, it's clear that everyone was proceeding on the basis that the DIFC orders were just reflecting what had been done in England. But that hasn't answered Your Excellency's question. I think Your Excellency is right as well, and in any event, that all that the first instance court and the Court of Appeal could possibly be taken to have resolved, if anything, is that there was an arguable basis rather than that there was good reason to suppose.
Yeah,
I think that distinction is obviously right, but my primary position is we just don't get there.
Yeah, okay.
Now, just finally on this point, there was a suggestion that Mrs. Gupta had accepted in her own witness statement that the basis for the Chabra jurisdiction had been established. Now, that is a reference to Mrs. Gupta's second witness statement. Your Excellency was taken to it, but it was done quite quickly. And I think I need to correct what that witness statement says and what it does not say. That is at C5 of the bundle. At page 760. And it's paragraph 7 on which my learned friend relies, where Mrs. Gupta says, although I'm not a defendant in the English proceedings, this court and the English court have established that there's good reason to believe that I hold assets that belong beneficially to Prateek and has restricted me in the use of those assets.
I must say that I read that as just a statement about the finding of the court?
Well, I mean, Your Excellency, there's several points about this. First of all,
no, it wasn't a concession being made by Mrs. Gupta.
no, absolutely not. And in any event, when one reads this witness statement, it's quite clear. But then follows on, paragraph 8, the restrictions. So we've just had the English court has restricted me in relation to the use of those assets, being the assets in relation to which there's good reason to suppose that they held on behalf of Mr. Gupta. Paragraph 8, the restrictions extend to the shares, the company registered in Dubai and fully owned by me named Vision. So that's what she's talking about, if anything. And then by contrast, paragraph 9, the assets I'm permitted to deal with or dispose of are identified in Schedule D. So what this passage is absolutely not saying is that the English court or the DIFC court has made findings that there's good reason to suppose that the Schedule D assets belong beneficially to Mr. Gupta. To the contrary, there's a contrast being drawn between paragraphs 8 and 9. But in any event, Your Excellency, really none of this goes anywhere because, as Your Excellency says, it can't be taken as a concession. The legal position is whatever it is. And the other point about this witness statement is it was served at a time when Mrs. Gupta was not benefiting from legal representation in the DIFC. It's been brushed over a few times, but as we'll see, Hilal applied to come off the record in November 2025, well before this witness statement was served. And the order granting that application was not made until February, but plainly Mrs. Gupta, having not paid her lawyers, was not benefiting from their assistance during this period. So it's not the sort of thing that can be held against her and set up to now obtain coercive orders in relation to her assets. Now, the final point on this heading before I move on is where Trafigura ultimately ends up. And they ultimately say that as a result of all of this history, that it is abusive for Mrs. Gupta to contest whether the Schedule D assets are amenable to execution. That's their ultimate submission. They say if Mrs. Gupta had wanted to mount that challenge, she had to do that in September 2025. I think the words Mr. Peters used was that she should have either put up or shut up at that time. Now, in the end, the question for Your Excellency, even if it's open to Mr. Peters now to make that submission, is whether at that point Mrs. Gupta could and should have raised the argument such that it is abusive now to do so. And in my submission, the answer is plainly not. But even if my learned friend is right to say that the Court of Appeal order must be taken now with the benefit of hindsight and close analysis to have determined this point, this amenability point, then it was far from clear at the time. It can hardly be said that it's abusive for her now to run that argument. And even if it were, the next question is, have the circumstances materially changed? And again, I would say the answer is yes. And that is because of the way things have unfolded on this application. And we come back to the beginning where my learned friend argued this point on the 23rd of February. The issue could have been pressed then, it wasn't. And as a result, we're now here before Your Excellency with a 2-day hearing, some very large bundles with lots of evidence that has been served and lots of costs that have been incurred because Trafigura did not press the point in February. And if necessary, I would say that is a material change of circumstance, and Mrs. Gupta should not be shut out at this stage from disputing the amenability of her assets to enforcement of the English judgment.
I've had a message. I apologise for interrupting my learned friend. Apparently the transcribers have asked for a break. I don't know if that's a convenient moment, but I thought I'd just flag it and then shut up.
As workplace
That's
occupational health and safety guardian, Mr. Peters, we thank you. And we'll break for 15 minutes. Thank you. Yes, Mr. Trotter.
Thank you, Your Excellency. I was then turning to Mrs. Gupta's discharge application.
Right.
Your Excellency will have seen that the ground between us has narrowed in at least one respect, in that my learned friend now rightly accepts that there was a duty of full and frank disclosure in the urgent application. That is a welcome development, but the position that has been taken by Trafigura in evidence remains of concern to us because it sheds light on the way in which the urgent application was approached in the first place. And Mr. Whelan's first witness statement takes the unequivocal position that there was no duty of full and frank disclosure. That witness statement is at E4 of the bundle.
Well, if it's not in contest, the real question is what's the scope of the duty in the particular circumstances of this case, isn't it?
Yes, that's right. I mean, our concern, putting it broadly, I'll come on to that in detail, but the concern putting it broadly is that this application, the whole application, was just approached on the wrong basis, and no one turned their mind to actually giving full and frank disclosure or fair presentation, and that's why it wasn't done. Now, in terms of the duty itself, there have been, even now, various attempts to try and minimise the duty because of the circumstances of the case. But I say that's wrong both as a matter of the facts, which I want to go to, and also as a matter of the law. Now, on the facts, there are four things that are said, as far as I can tell. The first is it said, well, this was all very urgent. Now, it's true that that point was de-emphasised this morning in my learned friend's submission, so I'm not going to deal with it in great detail. The short point is that the notice which precipitated the application was given on Sunday, the 26th of October, 2025. That was a full working week before the application was issued on Friday, the 31st of October, in which Trafigura put together the 6-page witness statement in support of it. So there was ample time to make the inquiries that needed to be made and to alight on the points which we have identified that ought to have been disclosed. The second point that's taken is that it said, well, Mrs. Gupta was on notice of the application. So that changes matters. But Your Excellency, that is only partially correct. The application, it is true, was served by email at 3:20 p.m. on the 31st of October, 2025. The reference for that is K302172. But the application was, even at that stage, sought urgently. It requested a hearing, if possible, by the following Tuesday, with one clear working day's notice, and alternatively by the Wednesday when it was in fact heard, which was also at short notice. So it ought to have been clear from the outset to anyone preparing this application that it had to be prepared on the basis of giving full and frank disclosure. But not just that, because the application that was served did not seek relief in relation to the vision properties. If we look at the original application notice, which is at D11206 of the bundle, starts at 1205.
Yeah.
1206, we see the substantive relief sought, paragraph 2, is an injunction in relation to Villa K3. Now, of course, that relief is not ultimately granted because the villa has been sold by the time the hearing comes on. The relief that is granted is in relation to the vision properties. And there is an amended application notice in the next tab, D2, 1209 of the bundle. And it's helpfully underlined so we can see what's changed. And the addition is the assets referred to in Schedule D. And so it's only now that relief is being sought in relation to the vision properties. This document is not dated, so it's not clear when it was issued. But I don't think it's in dispute that the amended application notice was never served. Mr. Fedrigoli gives evidence to that effect in his first witness statement, which is at E3/1310, paragraph 4, and that proposition is not disputed, as far as I'm aware, in any responsive evidence. So Trafigura's application for a Chabra injunction in relation to the vision properties is made without notice, without service of the application notice. And the further relief that was sought at the hearing, of course, including the order which ultimately nearly ends up with Mrs. Gupta being landed in prison, is sought without notice at the hearing, because it's only then that the circumstances relating to the sale of Vision Filler K3 are discovered. So again, it should have been clear for any of those reasons to everyone on the team that the duty of full and frank disclosure applied. The third point that's said about the scope of the duty is that Mrs. Gupta was represented when it was served. And that's been said a number of times in evidence and in submissions. It is, for example, in Mr. Whelm's first witness statement at paragraph 10.3, it's at E4/1339. Don't think we need to turn that up. But what Your Excellency has not been told is that Hilal, Mrs. Gupta's then DIFC legal representatives, had indicated 2 days earlier that they would be coming off the record. Now that is at K26/2166 of the bundle. And it's an email from Hilal, both to the DIFC court registry, but also copied, perhaps unconventionally, to Stevenson Harwood. And it explains that despite several reminders, the legal fees have not been paid. And accordingly, Hilal will be filing an application to come off the record. Now, the point is that Trafigura therefore knew when the urgent application was made that Mrs. Gupta would very likely be without legal assistance in responding to it. They must have appreciated the risk, for example, that Mrs. Gupta would not be in a position to piece together the procedural history, precisely what was determined by precisely what court in the twists and turns of the DIFC proceedings, to show that Trafigura needed to demonstrate a basis for the relief that they were seeking. The application wasn't made until the 31st of October, well after this email was sent. That's the third point. The fourth point about the scope of the duty that's been taken is that it's said that Mrs. Gupta responded to the application. And so therefore that somehow affects the claimant's duty to draw relevant matters to the judge's attention. Now, at the outset, this point I say is just irrelevant because, of course, the response comes after the application that's issued and after the evidence that is served in support of it. So even if it were a good point, which it's not, it doesn't excuse the failure to address full and frank disclosure in the application and the evidence itself. But again, it's only partially true because the document that keeps being referred to as a skeleton argument, can't now recall if Your Excellency was taken to that, it's at D71249 of the bundle. It's entitled Respondent's Submission, dated 4th November 2025. It's described as a skeleton argument because it is vaguely in the format of one. No doubt Mrs. Gupta has seen various skeleton arguments in the course of these proceedings, it doesn't follow that this is a document that's been produced with legal assistance. And with the greatest of respect to Mrs. Gupta, it plainly is not the sort of document that has received much in the way of that assistance. We see it runs over 2.5 pages and doesn't really say very much of substance. Of course, all it's dealing with is the Villa K3 point, because that's the only application notice that's been served. But we do see over at paragraph 11 on the 3rd page, Mr. and Mrs. Gupta say it's clear that the applicants have no intention to engage with the substantive issues that form the basis of their application. Now, it's impossible to know what Mr. and Mrs. Gupta had in mind by that, but as it turns out, they're absolutely right. Now, the witness statements that have been referred to are equally very amateur documents. We see them, they're exactly the same, so we only need to look at one, D4, page 1218. My learned friend says, oh, well, this looks like a witness statement. It's got numbered paragraphs, justified text and a header. But when one actually looks through it, one sees, for example, over on page 4, but heading 8, the prayer for relief. Next page, respectfully submitted on behalf of the respondents. Now, if there was any doubt in Trafigura's mind whether Hilal was still assisting Mr. and Mrs. Gupta, then really these documents ought to have put it beyond any doubt. These are not the sort of documents that would be prepared if Mr. and Mrs. Gupta had legal representatives in the TIFC at the time. Now, Mr. Willen says that if a duty was owed, it was sufficient during the hearing to address the points that were made in these short documents. I'll come on in a moment, but that is not the right approach on the authorities. But what I say standing back from all of this is it's striking in these circumstances that full and frank disclosure is simply not addressed anywhere in Trafigura's skeleton argument or in its evidence. And until recently, it was arguing that there was no such duty. What all of this really shows is that the application was just approached on completely the wrong basis. The duty required Trafigura and its lawyers to stop and consider the points that could be made against them. The law on this issue is trite. It's been usefully restated in Tugashev and Orlov, on which both parties rely. And Your Honour asked this morning, what is the scope of that duty? And there are really two elements to it in this case. The first we can take from Tugashev, and that is that the duty is to draw to the attention matters that are material. And what is material is a question for the judge, not for the parties. Perhaps rather than me badly phrasing it, it's better just to look at the actual authority, which is at Authorities Bundle tab 32. It's page 821. It's a useful summary because it gathers together various points on which each of us have relied. I'm not sure if Your Excellency has that in PDF or hard copy.
No, I'm just trying to get it at the moment. Just go ahead and take me to the passage there, will you?
Yes. It's at page 821 of the bundle, which is paragraph 7 of the judgment. There's a list of the non-contentious principles.
Yeah.
We see that the court, principle 2, the court has to be able to rely on the party who appears alone to present the argument in a way that is not merely designed to promote its own interest, but in a fair and even-handed manner. 3, the judge must be able to have complete confidence in the thoroughness and objectivity of those presenting the case. 4, the applicant must make proper inquiries before making the application. He must investigate the causes of action and the facts relied on. And so in short, it's an obligation to stop and think about what should be disclosed. And then as to what should be disclosed over the page, material facts, paragraph 5, are those which it is material for the judge to know in dealing with the application as made. The duty requires the applicant to make the court aware of the issues likely to arise and the possible difficulties. It does not extend, of course, to a detailed analysis of every possible point which may arise. And 6, this is the point on which Mr Macpherson relies. There will be degrees of relevance and a due sense of proportion must be kept. Of course, that's right. Sensible lines have to be drawn. But the question is, are the matters which were not drawn to the judge's attention material in the sense that they would have been relevant to the decision which His Excellency was making? So that's the general duty. Now, the question is, how is that affected in circumstances where there is short notice rather than without notice? And the answer to that can be found in the leading practitioner's text on civil fraud in England, Grant and Mumford, which is at Authorities Bundle 49, page 1410. And the authors quote from CEF Holdings and Mundy.
Yeah, right. Which paragraph are you looking at? Sorry.
So I'm sorry. It's the top of page 1410 of the bundle. It's the continuation of paragraph 27.060.
Okay.
There's a quote there where the position is described. And it says, the duty of the applicant who makes an application with less than the prescribed period of notice is to give full and frank disclosure continues even when the opposing party is represented on short notice, which of course was not the case here, but the Guptas were given short notice but were not represented. And then this is the qualification. Significantly, he is absolved from that duty, but then only in respect of those legal and factual matters to which the other person has drawn the court's attention. So it's of course not necessary if someone shows up for the other side to repeat all the points that the other side has made. But then I stress that he is not discharged from his duty to give full and frank disclosure in respect of any other matters. And this duty is well known to anyone practicing in this area of the law, that if you'd make an application on short notice, you need to give full and frank disclosure as though you were making it without notice. Now, before I move on to the particular breaches, very briefly on the transcript point, my learned friend characterises the failure to provide the transcript as a technical objection, which really had no consequences. Well, in the event, it hasn't had consequences because we've now been given the transcript and had a chance to review it and put in the discharge application on the basis of it. But it could well have had real consequences, because when my learned friend's Chabra application came on before this court in February, we didn't have the transcript. And the current legal team had been instructed only very shortly before that hearing. And because the transcript wasn't provided, we weren't able to make points on the basis of it. And it wasn't provided until after Trafigura had tried to claim the costs of the transcript from us. Now, I accept that that's not deliberate. The emails show that it was an administrative oversight, but it's just an indication of the way in which this application has been conducted. Can I turn then to the particular breaches that we allege and Trafigura's responses to them? Now, Your Excellency will have seen that they're set out in Fedrigoli 1, and my learned friend has taken the usual MEX objection to the length. But there's a tension, of course, in this, because the authorities make very clear that the respondent has a duty to particularise any breaches of full and frank disclosure. And that's what Mr Fedrigoli has quite properly done. Now, we've identified 3 particular respects in which the presentation to Justice Sir Jeremy Cook was neither full nor frank nor fair. And the first of those is the basis for Chabra relief and the fact that the need to show such a basis was not drawn to the judge's attention. Now, it's not controversial that that point wasn't drawn to the judge's attention. All of the extracts are collated in Mr Fedrigoli's statement, and I'm not going to go through them. And my learned friend, Mr Macpherson, took you to the transcript where Justice Sir Jeremy Cook therefore was left with the impression that, in His Excellency's words, we don't need to go there because the Court of Appeal order had already established the basis for the Chabra jurisdiction. So there's no dispute that the point was not drawn to the attention of the judge, nor is there a dispute, as I understand it, that the point is material. It plainly is. It's the basis for the entire relief that was sought. Now, of course, my learned friend says he didn't need to disclose it, and Your Excellency will determine whether he's right about that or not. Whether he's right about the fact that it had in fact been established or not. But we say that in any event, it was obviously arguable. Now, Stevenson Harwood had, of course, had carriage of this matter throughout, from the time when the order was sought from His Honour Judge Pelling in England. And Stevenson Harwood must have been aware of the background and the basis on which all of the orders were sought. Now, it was said that this is not the sort of thing that could have been anticipated. I have to say, the point was obvious to me when I picked up the papers, and it was obvious to the Chief Justice at the last hearing. And it is the sort of thing that if someone had been involved in the proceedings throughout, really ought to have been raised. Now, of course, I don't say the same thing about Mr Macpherson. He was not involved in the application before His Honour Judge Pelling KC, and he was not involved in the Court of Appeal hearing before Your Excellencies. He was, of course, advancing the position on the basis of what had been provided to him in evidence. And I'm confident that if Mr Macpherson had been made aware of the history, then he would have properly drawn attention to it. So that's the Chabra point. The second category is in relation to the breaches of the DIFC freezing order. And really this came into critical focus before the judge because the application was not made on the basis that the assets were amenable to the Chabra jurisdiction. It was made on the basis that a variation was sought in light of Mrs. Gupta's conduct. So that was squarely in issue. I'll take these as quickly as I can, but I need to address them not only because they're relevant to full and frank disclosure, but also because Trafigura continues to rely on these alleged breaches as part of its own variation application. So it's relevant not only that certain points weren't drawn to the judge's attention, but also that we say the order being, the interpretation being given to the order is unduly expansive. And it would be wrong to infer that Mrs. Gupta will not comply with notice provisions because of the way that things have unfolded to date. The first point is in relation to the Villa K3 notice. Now, I say this is of particular significance because in relation to this, the question is not whether the construction of the order was correct or correctly portrayed before the judge. Rather, the question was whether notice had been given at all. So if we start with my learned friend's skeleton argument for the application, that's at C6, page 1241 of the bundle. And we see on internal page 15, there's a heading C2, interim injunction order. And paragraph 61 explains that this is the section that sets out the justification for the interim relief. Paragraph 63, there's a history of R2 failing to perform the Schedule D obligation. So this is front and center of the reasons why relief should be granted. And the very first of those in the list is at subparagraph 1. It said no Schedule D notice of any kind was provided in relation to the first proposed sale of Villa K3 referred to in the R2 asset disclosure on the 21st of May 2025. Now, again, no doubt this skeleton argument is just drawn on the evidence which Mr. Macpherson has been provided. We see that evidence, which was Laken 3 at C3 of the bundle, page 1213. That's paragraph 13 of this witness statement. Mr. Laken says, as set out in MDL2, that's Laken 2, which is largely adopted by reference throughout this witness statement, the second respondent committed a previous breach of the notice requirements in Schedule D in respect of Villa K3. In summary, the second respondent indicated that she had agreed to sell Villa K3 in the R2 asset disclosure served on SH Dubai on the 21st of May 2025. Now, the clear implication of that is that the first time that Trafigura has been told of the intention to sell Villa K3 is in the R2 asset disclosure on the 21st of May 2025, after the agreement has already been signed. We see the same thing. This witness statement is referring back to Laken 2, and Laken 2 is at C2 in the bundle. And it's page 727. Do tell me if I'm going too quickly or too slowly with the references.
We're coming up to time in a little while, Mr. Trotter.
Yes, perhaps if I can finish this point.
Yeah, I'm just letting you know, but yeah, by all means.
Yes. And so it's paragraph 13, where it says, in her asset disclosure served on us on the 21st of May 2025, the second respondent indicated that she had agreed to sell Villa K3, stating, and then quote, a Form F has been signed for the sale of this property. No prior Schedule D notice under Schedule D was provided. Now, if this statement were true and complete, this would obviously be highly material. It is presented as an indisputable breach in relation to the same asset in relation to which the urgent application is issued. And the allegation is not just that Mrs. Gupta failed to give adequate particulars. The clear implication is that the court is that Mrs. Gupta has previously agreed to sell the same asset without giving any notice at all. And that really is central to my learned friend's position that a notification injunction is not adequate, because as Mr. Peters was explaining, its position is that Mrs. Gupta just cannot be trusted to give notice. But Your Excellency, this statement is not true and complete. It is misleading because notice was given on the 1st of May 2025, several weeks earlier than the asset disclosure, which is being referred to, and several weeks before the sale was agreed. Now that email is at U38034. It's an email from the 1st of May from Preston Turnbull to Stevenson Harwood. It refers to Schedule C of the order. It gives notice of the proposed sale, the price, and confirmation that the proceeds will be used as required by the order. And it explains at the bottom that that includes pending payments to suppliers of vision. Now, the reason, of course, why this notice is given pursuant to Schedule C of the English order and not Schedule D of the DIFC order is that the DIFC order has not yet been served. The DIFC order is not served until the 19th of May 2025. Reference for that is at A14212, paragraph 8. And so, of course, the notice is not given pursuant to Schedule D. Now, this, I say, is of particular concern where we see how this evidence has come about. Because if we look at Mrs. Gupta's asset disclosure, which is being quoted throughout this evidence, we can see that a material part of the quote has been omitted. That's if we turn up B1438, there's a table that sets out the asset disclosure, and there's next to Villa K3, there's an asterisk. And then underneath that, we have note in bold text. And underneath that, there's the asterisk. And it says a Form F, brackets MOU, has been signed for the sale of this property and intimated to Trafigura under the terms of the UKWFO. And I underline those words, and intimated to Trafigura under the terms of the UKWFO. It is a clear reference to the email that we have just seen that gave notice to Stevenson Harwood about this very sale. And then that is drawn to Stevenson Harwood's attention again in the asset disclosure given on the 21st of May, 2025. If we then just go back into C2, 727, back into Lakem 2, where we see this quoted, paragraph 13 that we were looking at before, in her asset disclosure served on us on the 21st of May 2025, the second respondent indicated that she had agreed to sell Villa K3, stating, and quote, a Form F has been signed for the sale of this property. End of quote. No prior notice under Schedule D was provided. So, Your Excellency, the person who is drafting this statement has in front of them the asset disclosure, which specifically says that notice was given under the UK freezing order. The drafter has specifically decided not to include that part of the quote, which would indicate that notice had been given. And then the drafter decides in the very next sentence to state that no prior notice under Schedule D was provided. Now, it is difficult to resist. in my submission the inference that we are in the territory here of careful drafting, as we have said. Now, can I show Your Excellency then that was made perfectly clear to Stevenson Harwood in Mr. Fedrigoli's statement, which is at E31324 of the bundle. And it's paragraph 41.2. Mr. Fedrigoli says, as I've just submitted, the drafter must have appreciated the importance of omitting the underlined words and intimated to Trafigura under the terms of the UK WFO, because the very next sentence stated no prior notice under Schedule D was provided. That was careful drafting designed to be defensible as technically accurate in stating that no notice was given under Schedule D, but intended to give the misleading impression that no notice had been given at all. And Mr. Fedrigoli then says over at page 1332, paragraph 63 and 64, it's very difficult to understand how these misleading statements could have come to be made without anyone realising. Further, as noted above, the omission to mention Villa K1 notice appears to be the product of careful drafting in more than one document, decided to be technically accurate but materially misleading. The matters above call for a properly particularised explanation in evidence from a legal practitioner at Stevenson Harwood with direct knowledge of the matter. Directions have been given to permit Trafigura to serve evidence, and they have 3 weeks to respond. It ought to be straightforward to provide an explanation. Now, Your Excellency, it would have been straightforward for someone to explain, if it was the case, that somehow this was not misleading. It is very difficult to see how the drafter of this statement could have intended anything else. But there is no such evidence. And instead, Stevenson Harwood come off the record only days after this application is filed, and Mr. Wilm can do only what he can do, which is make submissions in his evidence in response. Now,
Okay, Mr.
before...
Trotter, I think, Mr. Trotter, how much longer do you have to go on this point? Just this particular matter?
I think I can pick up most of it tomorrow, but I do just want to say one more thing before leaving, and it's for Mr. McPherson's benefit, because I don't want anyone to be leaved. Now, what I do not say, and what I want to make absolutely clear, is that Mr. McPherson was being deliberately misleading in his skeleton argument. And plainly, he has taken his wording from the evidence which has been provided to him. That's abundantly clear because his skeleton argument reflects the same wording. I, of course, don't say that Mr. McPherson was aware of the 1st of May notice or that he was deliberately misleading the court. That's made clear in Mr. Fedrigoli's statement as well. The problem is that the evidence on which it was based was not full, frank and fair.
All right, thank you, Mr. Trotter. So how are we going in terms of time generally, and how long will you take for the rest of your submissions?
Your Excellency, yes, my sense is that there is an awful lot to get through in these applications, and so the more time that we can squeeze out of tomorrow, the better.
Time to a lawyer is like the vacuum to nature, rushes in to fill it. I'm not pressing you. I just wanted to get an estimate. That's all. We'll have to finish tomorrow, of course, and we have to have allowed. And I think we're making reasonable progress, though. So we'll. It's now maybe lunchtime in London, but it's dinner time, well past dinner time in Perth. So we'll adjourn at this point. Thank you.
Thank you.